May I use this opportunity to welcome everyone. It's been awesome since Monday when we actually started this function. And today is a bit different. Lamu's my name, and I have few minutes to spend here today. Big thanks to the University of Lagos Law Alumni Relations Committee for bringing me here today. At this juncture, distinguished ladies and gentlemen, would like us to please rise for the national anthem of this great country, Nigeria. Shall we rise, please? Thank you. You may be seated. Thank you. With us here today is the Vice Chancellor of this great university, distinguished guest representing the Vice Chancellor. We have the Deputy Vice Chancellor, Academics and Research of the best university in Nigeria. Let's put our hands together for Professor Familoni, please. Thank you. I'd like to recognize the presence of the Dean of the Faculty of Law, Professor Ige Bolodeoku. Please put your hands together. The Chairman, University of Lagos Law Alumni Relations Committee is also here, distinguished Professor Taiwo Oshikpiton, SAN. My very good friend is also here seated. We've known each other for over 25 years, but now he has an assignment in Ibadan, or your state, am I correct? Professor Oyelowo, please put your hands together for him. Professor Oyelowo, I'm happy that you're using the nose mask. So when I said my very good friend, I didn't see the expression because of the nose mask. Thank you so much. Well, because of our time, I will continue with recognition of some of our distinguished guests here seated. I recognize the presence of friends of the community here present today, directors of different departments, the deans, but as we move on, we recognize our dignitaries here. Because of our time, for the welcome address and introduction, I'd like to bring on stage Mrs. Funke Agbo, SAN. Let's put our hands together, please.
Let me set the scene. It was the year 1977, and I was 18 years old. Can you imagine? I was 18 years old. That was the beginning of my University of Lagos Faculty of Law experience. The years I spent here were some of the most exciting and exhilarating and most profound as well. Some experiences I can share with you, others, no, not so much. But I think unforgettable is the word, and that should be the same for every student of the Faculty of Law today. That the faculty has produced some of the greatest and most well-regarded lawyers in Nigeria and in the world is unquestionable, and that this will continue to be the case is guaranteed, which makes the idea of an alumni reunion or homecoming infinitely significant. And since this has not been done until now, timely. It is also one for creating opportunities for the current students to gain immensely from the experiences, both good and not so good even, of those who have gone before them. So I am extremely delighted, and it is with great pleasure that I welcome all of you, the Vice Chancellor of the University, Professor Oluwatoyin Ogundipe, represented by the DVC here present, all the management and staff of the University of Lagos who are here present, the Dean of Law, Professor Igebolo Deoku, here present, and all the lecturers of the faculty, and all of you students, all our esteemed guests, you're all very, very welcome. We are so glad to have you here. We have here before us an array of judges, lawyers, senior advocates, the who and who of the legal profession in Nigeria, and of that we are extremely and profoundly proud. Now, what are we doing here today? The colloquium here today is part of a series of events that we have organized as the Alumni Relations Committee in conjunction with the Faculty of Law to bring back our alumni to the faculty. The event kicked off on Monday with a number of guest lecturers, alumni guest lecturers coming to the faculty between Monday and Wednesday of this week, lecturing students on various subjects. Some of these lecturers included Honorable Justice Helen Ogunmiju of the Supreme Court of Nigeria. She lectured students on evidence yesterday. We also had Mr. Olumide Shofora, SAN. We had Mr. Lekon Yusuf, SAN, on land law, Mr. Hakim Oguniran on housing, and a number of other of our star students and alumni who lectured the students during the week. And I think it was very exciting for all of them. So today we are here on the fourth day of the event, the colloquium. And we are going to be discussing, well, serious issues, one of which is the issue of stare decisis and the future of law in Nigeria. And here we have to present the keynote speech, our very well-revered Professor Fidelis Odita, QC, SAN, who is with us here this morning. And after he has delivered his speech, we will have a panel of discussants led by the chairman of the session, Professor Agomo, and along with her would be Honorable Justice Oluwatoyin Paye of the High Court of Lagos State, Professor Bangboshe, who will be joining us virtually, SAN. Also, we have Alhaji Bashir, a senator of the Federal Republic, who will be discussing also along with the discussants, and Professor Oyewo, SAN, also will be one of the discussants. So it is with great delight that I'm welcoming you all here. We have all sorts of senior lawyers here present, and we really appreciate all of you for coming. Thank you very, very much.
All right, thank you. I know that some people are watching this online, and of course the radio station is also beaming this live. So for those that are not opportune to be here today, you can send a text message to them. All they have to do is to tune to 103 the 1 FM, and they can get to hear all that is happening today. Moving on because of our time. The chairman of this event today is no other but distinguished Professor Taiwo Oshikbiton, SAN, Chairman, Alumni Relations Committee. He will give brief remarks, and after that, we'll move on with the function, please.
The Vice Chancellor of the greatest university, Professor Oluwatoyin Ogundipe, ably represented by DVC Academic and Research, Professor Familoni. May I just, because of time, stand on existing protocol in terms of saying that all constituencies are recognized, my lords from the bench, the senators from the National Assembly, our colleagues in the faculty, the Attorney General of Oyo State. I don't know whether to say he's one of us or he's there, but he's on loan. He's still one of us. And distinguished members of the inner bar. I can see the former Attorney General of the Federation here, Odeyin Ajumogobia, SAN. You are welcome. I also see, I call her my mommy, but I'm twice her size. Retired but not tired, Professor Chioma Agomo. You are welcome. And of course, our dependable and amiable Dean of Law, Professor Bolodioku. Of course, from Lagos Judiciary, I have Justice Oluwatoyin Ipaye, one of the panelists, also with us. And those of you who want to run away from litigation to arbitration, I have Shade Ali here as an arbitrator, so you can see her to further your interest in arbitration. Well, there's also Toyin Bashoron, SAN, also my own student and birthday mate, in whom I'm well pleased. Of course, my teacher is here, always supportive, Professor Emmanuel Akonki. You are welcome, sir. Mrs. Agbo has welcomed us, but in so doing, she has also told us why we are here. So I could as well say that, with apologies to you and others who belong to the constitutional family, that Ms. Agbo has covered the entire field, and there's nothing more for me to say, beyond saying that I adopt whatever she has said as mine, and I say no more. Then I can go down. But the Dean of Law is saying, no, haven't gotten there, you must add your footnotes. In other words, I must still say something. Well, we are here as part of the celebration of the first maiden homecoming event. Your faculty was established almost 60 years ago as one of the maiden faculty of law, of maiden faculty of the University of Lagos. Ever since then, the faculty has gone ahead to produce what we call fit-for-purpose lawyers and captains of the industry. We are not only the first, we have no equal. So we need to keep the flag flying. Today, I know of no faculty of law that has produced, as we speak, not less than 4 sitting justices of the Supreme Court. Supreme Court has a company of 16 or 17, but this faculty is so greedy that we have grabbed 4, 1/4 out of it, leaving the others for other people, for other faculties, including our friends from the provincial universities. They know themselves, they are here. So we've done very well. We have, as we speak, not less than 100 senior advocates of Nigeria from Faculty of Law. So we have every reason to celebrate because we are consistent. But you and I know that in legal system and legal methods, the first thing we are told or taught is stare decisis, or to break it down to non-lawyers, still lawyers also, judicial precedents. That remains the cornerstone of our legal system. That take away judicial precedent and stare decisis, there will be confusion and anarchy. What it means is that similar cases must be decided similarly, unless it is overruled by the Superior Court. That means that in our profession, there is law and order, and there's respect. That's why when judges come in, we bow for them. Even if they are my former students, when I see them, I must take a bow. Later on, maybe privately, they may try to kneel down or prostrate, but when we are there, we have to bow for them because there's order in the profession. And one of the evidence of such order in the profession is judicial precedent, that judges must respect decisions of higher authorities. Supreme Court stands as the apex court, followed by Court of Appeal, and followed by High Court. No High Court would dare judge, would dare to overrule Court of Appeal and say, thank you, I don't agree. That will amount to what they call judicial impertinence and also judicial rascality. And nobody wants to be allowed to accuse of judicial rascality. But today we are here to discuss serious business. We looked at the various decisions coming from the apex court and Court of Appeal, and we are able to find conflicting decisions. And as lawyers, we are unable to advise clients properly. There was a story of a lawyer who advised a client on a transaction based on a particular law, or based on the decision of the Supreme Court on a particular case. And by the time the thing resulted into litigation, there has been a contrary decision from the Supreme Court. And his client was accusing him of not giving informed legal advice. His answer, the typical lawyer, he said, my advice was as at 2015, before this 2020 decision. In the eyes of the client, he doesn't seem to know what he's saying. But how come you are having Supreme Court, Court of Appeal, having decisions that are conflicting here and there? So the issue is certainty in the law against uncertainty in the law. Where do we stand? How do we resolve all these conflicting decisions? Are we likely to have respect? Is our profession likely to be respected in the next 10 years if we continue with the pattern that is going, whereby you have one decision of the Supreme Court today, the next month another decision, the next month again another decision. Same thing also Court of Appeal. Then of course, the lower courts are bound by such decisions. How do they navigate in all these issues that are arising? Ladies and gentlemen, that is why we are here. And we are happy to say that we have assembled a panel of people who know what they are doing. In terms of perspective of judiciary, you have Justice Ikpaye of Lagos High Court, our own alumnus. From the National Assembly, we bring you good greetings and also exhibit him to come and showcase what National Assembly can do. That's also our own Senator Ajibola Bashiru. When we were going to give him a topic, I wasn't too sure whether we should give him academia or executive, because he wears two caps. He's one of us here, and he's also there in Oyo State, representing us very well. Highly cerebral, ageless Professor Oyolowo Oyewo, SAN. They are all our products, and they are doing very well. And we have brought them here to inspire the students and young generation of lawyers. Finally, the keynote speaker, we searched and searched. We didn't have any difficulty. He's reputed for having a large brain. He had the first class in this university, first class also law school. His record in Oxford and Cambridge remain unbeaten. And he has a reputation of, in England, they said he has a large brain. Whatever he does not know is not worth knowing. May I present as my main exhibit this morning, exhibit Odita 001, Professor Fidelis Odita, Queen's Counsel and Senior Advocate of Nigeria. So on that note, I say, well, welcome, sit down, enjoy, and have fun. Thank you.
Moving on, I'd now like to invite the Dean of the Faculty of Law, Professor Ige Bolodioku. Let's put our hands together, please.
the Vice Chancellor, ably represented by the Deputy Vice Chancellor of Research and Academic and Research, my lords here present, and of course, all of whom are also alumni of this great faculty and this university, our distinguished guest lecturers, the keynote speaker, and of course, our great students of the Faculty of Law. I want to really quickly appreciate my immediate predecessor in office, Professor Ayodele Ashenoa, the DVC, DS, for dreaming today, for seeing that it was possible to assemble all of our alumni, bring them back home, and relate to our students. It is happening. So this is indeed a very welcome development for our faculty and for our students. And for our students. Students, put the hands together for yourselves. We are beginning from Monday. We have brought here our great superstars, ambassadors, from justices of the Supreme Court that you had met in class. In my days as students, we read about them in law reports. We hardly see Supreme Court justices in person. We just read their judgments. Even the Court of Appeal justices, the High Court, we don't see them. But here we are. You have been interfacing with justices as lecturers. It is unique opportunities for all of us. It's also a forum through which you are now enabled to envision what tomorrow could be for you. And I'm confident that the kind of interaction they had offered, the kind of mentorship that you've taken away from what they had said, and the reality that it is possible, if you can will it, if you are disciplined enough, is humongous advantage to our students that are currently in the faculty. And in so saying, I also want to thank the Alumni Relations Committee for working so hard, hours and hours, days after days, because they're working with me, so I know how much effort they have put into this to make this a reality. And for all of those that are part of that committee that have made this happen, I thank you indeed. I thank you. As the chairman of the Alumni Relations Committee has said, we are dealing with an issue in our justice system, stare decisis. I will not delve much into it because there are superstars here to deal with this issue. But this I would say, that the topic is so important. And as it has its own microeconomic implications, if the justice system, if our decisions are not predictable, it puts a cost on negotiation. It also adds more cost to seeking justice in our judicial system. The micro aspect of it is that for those that are investing in the country, they also study all of these issues, how predictable our judgments, how reliant, and how stable our decisions, of course. Because all this affect them in their own investment decision making. So it is important that we address it and we take a whole lot from it so that we can get it right. It's also important for politics because if we cannot predict what the law will say, then, and most of these judgments affect our political sphere, then of course there could be problems down the road for us. So it is this important, this topic is this important. The good news is that as the chairman of our Alumni Relations Committee had said, we had put together distinguished guest speakers. Happily, all our alumni from this faculty, again to come here and showcase to us the culture of excellence that we have infused in them. You can't get it better than the keynote speaker, as the chairman had mentioned, but also the discussant. You have series and series of them who have been around, who have also been very great ambassadors to us. They are the people that will be talking to us today. And it's also heartwarming for me that we are able to bring all of this together this week to discuss issues, to interact with students, to mentor our students, and also to ask about the faculty they left years ago. As I've told them on Monday, the Faculty of Law is not particularly the same faculty they left behind. It has become a very big faculty now. We, as administrators of the institution, we're trying our best as much as possible to ensure that we continue to maintain our standard, because it is those standards that have given us our reputation as the nation's pride and also the faculty of first choice. And I want to thank all of my colleagues, my predecessors in office, our professors who are present, who are retired, who have put in a whole lot of work to infuse discipline, to infuse this culture of excellence in us, which ultimately has produced all of those we have been seeing since Monday. I'm confident that for the current students, your time is almost here. Most of you will pass out of this faculty this year by God's grace. And I know that you too will take a whole lot from what you have been feeling, what you have seen, and come back a few years' time as great ambassadors of this faculty. On that note, I want to welcome you all here and wish you a very great listening to this lecture. Thank you very much.
I heard clearly the words from the dean of the faculty. One of the regrets that I have in my life was that I was not opportune to study in the Faculty of Law. I studied English in Unilag, then Masters in Mass Communication. If you finish with a third class from law, you will get a job better than the individual that finished with a first class from any other university. If you finish with a pass from law in Unilag, you will get a job better than anyone who finishes with first class, whether in Osuka, Lasu, Ife, OU, Obafemi Awolowo. Come on. I know some of our lecturers wouldn't finish from Unilag here seated, and our distinguished guests are looking at me like, can you just get out of that seat? Come on. All right, moving on with the function today, distinguished guest. I'd like to invite the #1 citizen of this great university, the Vice Chancellor of the University of Lagos, Professor Oluwatoyin Ogundipe. Representing him is the DVC A&R, Professor Familene. Keep clapping till it gets to the stage, please.
Let me first start by giving the apology of the Vice Chancellor, Professor Oluwatoyin Ogundipe, who is unavoidably absent. He's not around, he's been called to Abuja. But you can note his passion for you, that he was supposed to leave on Monday, but he stayed back to make sure that he was part of the opening ceremony. I hope you accept his apology. The Dean, Faculty of Law, University of Lagos, all other deans here present, the keynote speaker, who have been described as a great representative of Faculty of Law, and Professor Fidelis Odita. If the distinguished Professor Shikpida said that he has to lean on the existing protocol because of error that he may perform, and because there are so many judges here who can send me to jail if I do anything wrong, I would like to lean on the existing protocols so that I will not do anything wrong. It is my privilege to be here today to see this homecoming happening at Faculty of Law. What is happening here is why so many students who are prospective students will stay back for 3-4 years, making sure that they come to the Faculty of Law. Because if you go for any interview or law-related matters, you go to any court for law-related matters, even in a company's related matters, they will see that it is alumni of University of Lagos that will be there. And in order to be part of that great network, they make it so difficult for others to come because people will study very hard to come to University of Lagos, Faculty of Law, and other faculties in the university. There were times when we were asked as management to say, pick your star faculty that you can be sure of and you can boast of. Faculty of Law usually come to mind because of what you've been told that there were almost 100 sons from University of Lagos, 4 sitting, not only currently, not for all time, but 4 sitting justices of the Supreme Court. It does not come very cheap. That is why we say we are University of first choice and the nation's pride. It is not for free, we say so. So I'm happy to see large numbers of people from the pictures of those who have passed through this place. I'm therefore happy to be part of those who have passed through this place by 1st degree, 2nd degree, 3rd degree, are all from University of Lagos. And I've stayed back to teach. So I'm very happy to be part of this thing that is happening today. The homecoming, which is a very great thing, we give opportunity for those who have passed through this place, and when they see what is happening there, they have opportunity of giving back to the university. They have opportunity of knowing what is not what they expect of their university and to be able to give back. And it's also opportunity to inspire upcoming lawyers that are still in school to perform better. So it is a very great thing, which I will suggest to the dean or the management of the Faculty of Law to make it an annual homecoming, which is normal in other climes, in which people have opportunity of giving back. Faculty of Law is special because all their students, 10 students are going, you can know those who are Faculty of Law, because they usually comport themselves and they are well dressed by I think the prior professor Gomo or those preceding or after you that made it important that everybody should start getting ready for the profession which they are planning to go into. So, on behalf of the Vice Chancellor, I welcome everybody to this meeting and to listen to this very important topic that is happening. It is not just out of the blues. I think recently the Chief Justice of Nigeria had to sanction some people because of what is happening. And so this is one of the ways in which the academic community can be part of the solution to what is happening. I'm sure the kind of people that are here, by the time they give their opinion, it will become one of the, it can be cited also, because they know it's going to be a very great one. On behalf of the Vice Chancellor and management of the University of Lagos, I welcome you all, especially our senior people. I can see Professor Akoki, those who have gone far ahead of us back to the University of Lagos, and hope that you have a very wonderful time at this university. Thank you very much.
If you are clapping for the Vice Chancellor, you can do better. Come on. Thank you, Professor Familoni, Deputy Vice Chancellor, Academics and Research of the University of Lagos. Before I invite the next, I'd like to recognize the presence of Dr. Babajide Martins, Director of Public Prosecutions. Please can we put our hands together? Mrs. Osai Ojigo, Amnesty International, you're welcome as well. Thank you. Chief Isiaka Olagunju, SAN, former General Secretary, Nigerian Bar Association, you're welcome. Also, Mr. Odien Ajumogobia, SAN, former Minister of Foreign Affairs, is also here present. You're welcome. And I invite for Memory Lane, Mr. Olayinka Ola Daniels, down Memory Lane. Let's put our hands together for him, please.
Respectfully, my Lord, VC, my professors, my SANs, permit me to stand on the existing protocol. Thank you. We're in a segment where we want to bring those memories back to us, why some of us were here. And for the people, for the new ones that are still here, to see what has happened in the past. The short documentary of the Faculty of Law, the student, the lecturers, the retired ones, the ones that are still there. We have two sections of this. There's a short clips that we're going to have today. And there's the bigger version, which we will upload to the cloud. After this program, everyone will have access to that, so that you go to that, we'll send a link to you, click on it, and download the bigger version. But for now, I present to you.
The Faculty of Law was established in 1962 as one of the foundation teaching units of the University of Lagos. Teaching in the faculty began in October 1962 with an academic staff of 5 persons, 2 Nigerians and 3 Englishmen, and 26 pioneer full-time students registered for a 3-year Bachelor of Laws LLB degree program. A 5-year part-time LLB degree program was introduced in January 1963 with 30 students, but the program was terminated in 2006. The faculty considers its role as that of providing sound university legal education in line with the UNESCO Advisory Commission's report, which proposed the establishment of the University of Lagos. Since its inception, the faculty has been committed to teaching law in the light of social, political, and economic context, nationally and internationally. The faculty was divided into 4 departments on 1st October 1977. They are Department of Commercial and Industrial Law, Department of Jurisprudence and International Law, Department of Private and Property Law, and Department of Public Law. The graduates of the faculty have over the years dominated various legal fields within Nigeria and beyond. To date, it has produced Supreme Court justices and more than 50 senior advocates of Nigeria.
Since the senior advocate rank was introduced in Nigeria, we have had over 75, of our alumni make that rank. And I think that with some of the latest elevations, we probably have crossed the bar into 80. And maybe a little bit above 80 by now.
There are 4 student law chambers, namely Taslim Elias Chambers, Kayode Esho Chambers, Oputa Chambers, and Gani Fawayimi Chambers. Other student co-curricular associations, which enable students deepen their practical knowledge of legal fields and hone their law skills, include the Mooting Society, established to handle all the various mooting competitions involving the faculty, the Maritime Forum, the Tax Club, the Oil and Gas Club, and the ADR Society. Some innovations were introduced in the nurturing of student-staff relations through an event tagged Bridge Time. which allows students to interact freely with academic faculty and discuss academic matters such as student academic performance and career prospects. Alumni of the faculty who have achieved notable success sometimes participate in this forum. The Deans of Faculty of Law, University of Lagos from 1962 to 2022, Professor L.C.B. Gower, Professor Taslim Elias, Professor Alfred Kasumu, Professor Michael Jegede, Professor Clifford Olawoye, Professor Michael Ajomo, Professor Anthony Adeogun, Professor Jelili Omotola, Professor Akintunde Obilade, Professor Isaac Agbede, Professor Emmanuel Akonki, Professor Adedokun Adeyemi, Professor Chioma Agomo, Professor Oyewo Oyelowo, SAN, Professor Imran Oluwole Smith, Professor Akin Ibidakpo Obe, Professor Ayodele Asenwa, and Professor Ige Omotaya Bolodeogu, current Dean of Law. The story starts in 1962 with Professor L.C.B. Gower, a foremost authority on company law, as a pioneer dean.
As a matter of fact, the man who interviewed me for admission at the London School of Economics, University of London, Professor Gower, told me that he was going to be the first dean of the Faculty of Law, University of Lagos.
His accomplishments and the stamp of excellence he left on the faculty were taken further by another giant, a man of many parts, Taslim Elias. Elias took over the mantle of leadership at a very turbulent time in the history of the faculty and the university. The inspirational leadership gap created by the unfortunate events of 1965 could only have been filled by no other person than a man of the caliber of Taslim Elias, who assumed the deanship of the faculty in 1966 at a most critical period. He had the singular honor of occupying the post of Attorney General of the Federation, as well as that of the Dean of the faculty. He promoted the culture of quality academic research and also initiated staff development programs, among other schemes. Alfred Kasumu succeeded Elias in 1964. However, his stint as dean was short because of his appointment as Commissioner for Justice, Lagos State. He nevertheless left his mark chiefly through the establishment of the JIC Taylor Lectures and inauguration of scholarships for excellence. The baton was handed to Michael Jagade in 1976. It was under his leadership that departments were created in the faculty. This singular feat helped in no small measure in the staff growth and development. It was also under him that the faculty recorded its first ever first-class graduate in 1977. After a 4-year purposive leadership tenure, Clifford Olawoye took over the mantle from Jegede. The crisis that rocked the university barely 7 months afterwards prematurely brought his deanship to an end. It is a salute to the comrade spirit among his peers that none of them stepped in to take his place. This is a demonstration of the oneness of the faculty. Each of the deans of the faculty, ever since inception, have left their indelible imprint, and the current dean will no doubt continue with the same zeal and commitment with which his predecessors served. Let's hear from some of the lecturers and alumni.
It was a great joy and delight to join the Faculty of Law, thanks to the good grace of Professor Kasumu, senior advocate, who hired me way back in 1973. So I was in the faculty from 73 to 2017. So you can do the arithmetic.
I joined the Faculty of Law, University of Lagos in September 1974.
I could say that as a lecturer in the Faculty of Law, I would verily agree with the current Vice Chancellor, who usually describes the Faculty of Law as one of the flagship faculties of the University of Lagos.
We have about some of the very great teachers here at the University of Lagos. We had used some of their books, even as students at IFE. And so I thought that it would be a very good opportunity to broaden my outlook by coming here.
I'm a professor of law for over 50 years. It can be like 53 or...
It's been a wonderful experience. Choice of University of Lagos to study law. Maybe they had 4 or 5 universities then. Even if they had 20 universities, the University of Lagos has no equal. We tower above every other university in terms of the study of law.
I was happy when Professor Ayo Agbede invited me to come and lecture in his department. He was the head of the Department of Jurisprudence and International Law at that time. So for me, it was like fulfilling a dream.
So I joined teaching as a lecturer too. And they said, oh, they were looking for someone to teach the law of torts, because Professor Konde, who was teaching tort, was tired of the subject. So I came in and they just foisted it on me.
Evolution of teaching law. Interestingly, when I joined the Faculty of Law, only full professors lectured. The others took tutorials. I did not see the inside of a lecture room till about 3 years or thereafter. So you have a maturing process, and it's like a synergy. The senior mentoring the junior.
I remember particularly Professor Akinwuye Bode, who was my teacher, and he was so brilliant and so smart, and I said to myself, maybe I could achieve this kind of success, and finally, by the grace of God.
When we were here as students, my lecturers, my professors then, Professor Adeogun, Professor Adeogun, Professor Adeyemi, Professor Obilade, and some of our professors that later, some of our lecturers that later became Professor Agomo, Professor Shikmiton, Professor Fogam, Professor Uzodike, Mowo, Oyewo, Professor Asenuwa. What they did for us at that time was that they went beyond the call of duty. They also impacted us personally. They cared about us. They cared about everything about us.
Where you are brilliant, you are my best of friends. And when you are weak, I will say you are even a better friend for me, because I feel, how can somebody come here and left here not improving himself or herself? So I go for weak students to help them in every way I could. Why the brilliant students are just my friend because I like them. And I'm open for whatever they want of me, advice or everything, and I'm fond of them.
I heard 1970, this 1960, that I was not even born then. Do we have any student here present that was born in 1970? Yeah, even some of your lecturers were 1970, really. But once again, I think it was a lovely video. Can we put our hands together? Well done. Well done, well done, well done. I'd like to recognize the presence of the following before we move to the address. So, Oluwole Akintayo, Ed Department of Jurisprudence and International Law, University of Ibadan. LLM graduate 1991. You're welcome. Also, Titi Lola Akinlawo, SAN. Let's put our hands together, please. Mrs. Chinwe Efuri is also here. Please put your hands together for her. Folashade Ali is also here with us. Can we celebrate her as well? Because of our time, I'd like to invite Mrs. Adejumoke Akimbosoye to kindly come up and introduce the keynote speaker, please.
It's a privilege to stand before my lecturers, professors, former deans, SANs, ministers past and serving of the Federal Republic of Nigeria. Permit me to stand on existing protocol. My work here is very short, and I'm introducing Professor Fidelis Odita, QC, SAN. Let's applaud him and appreciate him. Professor Fidelis Odita was born at Ibusa, Delta State. Professor Fidelis Odita was born at Ibusa, Delta State, Nigeria on the 27th of March, 1964, to Augustine and Vera Odita. He has 2 sons and 2 daughters. He was educated at the University of Lagos, where he was awarded an LLB degree and finished with a first class in 1984. At the Nigerian Law School, he graduated in 1985 and again finished with a first class and was awarded many prizes. At the University of Oxford, where he was a Commonwealth Scholar on a scholarship of the United Kingdom government between 1986 and 1989, he obtained several degrees, including his MA degree, BCL, and DPhil. Qualified as a Nigerian lecturer in 1985 and as an English barrister in 1993. He began his legal career at Oxford University, England in 1989 after his doctoral degree. Between 1989 and 1998, he was a fellow and tutor in law at Merton College, Oxford, and a Travers Smith lecturer in corporate finance law, the law of contracts, torts, company law, corporate finance, and corporate insolvency. As a tutor, he supervised and examined a number of doctoral students, both at Oxford and other universities all over the world. He also acted as an external examiner at the universities of Bristol, Nottingham, and the London School of Economics and Political Science. He was a visiting professor at the University of Virginia Law School in the fall of 1992. He left full-time teaching at Oxford in 1998 to pursue practice as a commercial and chancery barrister in the City of London at the South Square Chambers Gray's Inn, where he remains actually till this day. There, he practiced as a commercial barrister, providing transactional advice, drafting litigation, and arbitration services to clients, both in England and abroad. He became a visiting professor at Oxford, again in 2000, in which capacity he supervised and examined and gave graduate seminars, which he still does from time to time. In the year 2003, he was appointed a Queen's Counsel, which is what we know as the QC in England, and on his appointment as a senior advocate of Nigeria in 2004, he set up the law firm Odeta in Lagos and also in Abuja. Professor Fidelis is proficient in Nigerian and English commercial law, banking and finance, corporate law, energy and natural resources, and insolvency law. He has a large litigation and arbitration practice as counsel, expert, and arbitrator. Professor Fidelis has lectured and written extensively on contracts, banking and finance, company law, commercial arbitration, public law, legal practice, and insolvency. He is a bencher of the Lincoln's Inn, England. He is the president of the International Law Association, the Nigerian branch. He is the immediate past president of the Business Recovery and Insolvency Practitioners Association of Nigeria, popularly known as BRIPAN, and he's the editor of the BRIPAN Law Review. He was the inaugural president of the African Users Council of London Court of International Arbitration. And according to Chambers' Guide to the UK Legal Profession, Fidelis Odeta has a huge brain. What he doesn't know probably isn't worth knowing. You're welcome, sir.
Good morning, ladies and gentlemen. Like all the previous speakers said, I'd like to stand on the existing protocol. But I think from what the lady that read my citation said, you have to distinguish the substance from the hype. So when you hear that he has a big brain, it's all part of the hype that as a city barrister in London, you need to do in order to attract work. So you shouldn't take it too seriously. Unfortunately, that is a part that is often cited. While I like to stand on the existing protocol, I would like also to recognize 4 people. The first is my wife of almost 30 years, Priscilla. I'd also like to recognize 3 of my great teachers and friends. I'd like to start with Professor Emmanuel Akonki. And Professor Chioma Agomo. And Professor F.K. Fogam. I know there are many other distinguished professors, especially my friend, Professor Shupiton, but I did not have the privilege of being taught by them, so I'm not going to recognize them today. Professor Shupiton introduced the topic of stare decisis when he gave his more than brief opening remarks. So given that we all know in outline what stare decisis means, I think I can go through my paper fairly quickly. So decisions of courts which are higher up in the chain of command are generally binding on that court itself, as well as on courts lower down the chain of command. And this is what is generally known as vertical stare decisis, from top to bottom, which is dependent upon a hierarchical court system. And of course, in most systems, the courts are hierarchical. Lower courts should simply take the easy way out, not think too much, but apply the principles of law which have been identified in previous decisions by higher courts, unless they're on different facts, even if they think those decisions lack logic or are wrongly decided. As Professor Shubit also mentioned, any attempt by lower court to avoid or to refuse to follow decisions of higher courts be said to be impertinent and to exhibit judicial rascality, whatever that means. But it's not just a question of following the decisions of higher courts. In common law systems, the stare decisis or judicial precedents form a very significant and important source of law. And in the case of Nigeria, we all know from Section 32 of the Interpretation Act that the principles of the common law, the doctrines of equity, were among the laws received into Nigeria. And I know among scholars there's some debate whether the principles received were cut off in 1900 and frozen in time like the polar ice cap, or whether what we receive is a contemporary common law. In contrast with that, it's said to be the continental or civil law systems, including some OHADA systems in some African countries, which are based on codes that are, in theory, a complete and exhaustive statement of the law. And so when you have those systems, the continental systems, which are based on codes which pretend to be complete and exhaustive statements of the law, the judicial decisions are not binding. They are not said to be sources of law. They simply interpret what the code means. But of course, in practice, they can be highly persuasive. The judicial precedent is therefore based for its efficacy on an efficient and effective system of law reporting. It doesn't mean that undecided cases are not binding, but you need access to those decisions in order to know what they are. So you cannot have an effective system of judicial precedent unless you also equally have a robust system of law reporting. Excuse me. Let me just go through quickly what I regard as the very basics so that we can come to the really interesting parts. In Nigeria, you have the Supreme Court, which is bound by its own decisions generally, but is allowed or permits itself to depart from those decisions in cases that it regards as proper. And based on the existing case law, there are 3 or perhaps 4 circumstances where it might do so. First, where a decision is shown to be inconsistent with the Constitution, or 2, where it is shown to be per incuriam, or more arguably, more doubtfully, where a decision will perpetuate injustice and hardship. There are said to be other exceptions, for example, where a decision is contrary to public policy or prevailing public policy, but those are at best debatable, because the more exceptions there are and circumstances in which the court can depart from its own previous decisions, the less certainty there is in the application of previous judicial decisions. In the same way, the Court of Appeal is also generally bound by its own decisions and will depart from them or from its previous decisions in accordance with the English case of Young and Bristol Aeroplane, which says that the Court of Appeal will depart from its own decisions in 3 circumstances. First, where the previous decision is per incuriam, or where there are 2 conflicting decisions of the Court of Appeal, it is free to choose which one to follow. Although in Nigeria, there are some nuances on that exception, depending on whether it's an older or later decision. And then thirdly, what is regarded as implied overruling, where although a decision of the Court of Appeal has not been formally overruled, yet it is inconsistent with a subsequent decision of the Supreme Court, in which case it is deemed to be impliedly overruled, and the Court of Appeal will not be bound to follow that previous decisions. I mean, there are also some writers who take a slightly broader view by saying that in relation to the Court of Appeal, that whether or not the Court of Appeal is bound to follow previous decisions depends on whether it is a civil cause or a criminal cause. That in civil matters, the Young and Bristol Aeroplane is a governing position, whereas in criminal matters, because the liberty of a subject is at stake, that the court should apply more flexibility in the application of judicial precedent. But there doesn't appear to be much logic in that distinction, and certainly is a distinction which does not appear to be supported by the existing case law. In the High Courts are not bound by their own decisions, and they are not bound by decisions of other judges of the High Court. But their own decisions, the decisions of the High Courts, because they are at the bottom of a superior court, their decisions can be persuasive. So you could cite a decision of a High Court to the Court of Appeal or to the Supreme Court, and they might find such decisions to be persuasive. But unfortunately, in Nigeria, there's a lot of opacity surrounding the decisions of High Courts because most of those decisions are not reported, and so you don't actually know what it is that the High Courts are saying. Whereas in England, if you take the All England Law Reports or the All England Commercial or the weeklies, you will find that a lot of the cases which are reported are first instance decisions. But those first instance decisions are reasoned. So perhaps the High Courts will start doing justice to themselves by producing more reasoned decisions so that we can encourage the specialist law reports to report them. And you see that there is a real difficulty because when you take, say, schemes of arrangement, which is an important part of company law, in England, almost any time I open the Butterworth company law cases, I'll see a number of decisions on schemes of arrangement given by first instance judges. First of all, whether or not they should convene the statutory meeting. And secondly, what happens at the sanction after the creditors or members have met. But there is no single reported Nigerian decision on those questions. So when you are asked, what is the Nigerian law practice in relation to schemes, you have nothing to cite. Because I have done about 7 or 8 schemes, but not a single one of them gave rise to a reasoned decision, let alone a judgment. I've done more than 10 reductions of capital. Not a single one of them is reported. And so you ask yourself, how is anyone going to know what the law and practice is in relation to reductions of capital, in relation to schemes of arrangement? So you can teach students as much as you like, company law, the Bubble Act, the law of company promoters, and strange things like that. But the things that are important to lawyers in practice, how you reorganize or restructure your capital, how you do so by scheme, how you squeeze out minorities by scheme, or how you write off your deficit in your balance, in your profit and loss account by reduction of capital or scheme of arrangement, the students do not know. And you don't blame them because the teachers do not know themselves. And you don't blame them because there is nothing in the law report that will tell you how to do that. So that is a real deficiency in the decisions of the High Courts. It is not because they are there, it is because of lack of industry. And in comparison, as I said, when you look at the robustness of the High Court's decisions, even taking the Corporate Governance and Insolvency Act of 2020, there are more than 30 cases that have been reported on that piece of legislation that was passed during the pandemic of 2020 to help companies that have some slight connection with England. But in Nigeria, not just that there is no legislation, there is no reported decision of any sort. So there you are with precedent. But leaving that to one side, let me talk briefly about the supposed benefits of stare decisis or judicial precedent. There are said to be various benefits, and these include, 1, it ensures certainty and discipline in the judicial process, which is absolutely important. Secondly, it ensures consistency in the law. And thirdly, it's said to be a strong expression of judicial policy and provides for orderly development of legal rules. And fourthly, it's said to be an important aspect of the rule of law because obedience to precedent is an important expression of the rule of law itself. So when we say you must obey the decisions of the courts, it is important for the functioning of our nascent democracy that those decisions are obeyed, and those decisions are embodied in the consistent judicial decisions. And finally, it's said to foster the development of constitutional government and the stability of its institutions. And these are all very important benefits that one gets. But of course, from the point of view of a practicing lawyer and the future of legal practice, the most important aspect of judicial precedent is, as Professor Boladeku mentioned, the ability to advise your clients. Because when people consult lawyers, they're telling you to predict how this dispute is going to be resolved. They're asking you to predict how the court will decide. But especially in transactional matters, not even litigation. We say in litigation, it doesn't matter. The judge decides what he decides, and you appeal until you exhaust the appeal. But in the case of transactions, judicial precedent is even the most important, because many transactions are challenged years after they've been consummated. So you enter into an agreement to buy and sell shares or to buy and sell a company today. There is no dispute until some warranty period is about to expire 8 or 10 years down the line. And there is a dispute naturally. Someone did not disclose this, the disclosure letter said insufficiently, and you want to look for how you can claw back some of the payment. Or you want to get the amount retained, and the purchaser is refusing to release your retention money for you. So you want to litigate. You go to a lawyer. What is likely? How is a court likely to construe this? And in England, and that's why I refer to transactional advice, over 50% of our practice as barristers is advisory. So the solicitors have these transactions, they cobble them nicely, but then they come to the barristers. We see them partly as reinsurance, of course. They want to make sure that if anything goes wrong, they'll have someone to sue. But over and above the reinsurance that we provide to them is the fact that we actually litigate those disputes. So it's all very well for them to say 1 + 1 is 2. It's only if we're able to persuade the judge that 1 + 1 is 2 that that transaction will stand. So it's important for them to test those propositions with a barrister. And even in the field of insurance, you see that some insurance contracts provide for QC opinion. So before they will accept the policy or the risk, they require a QC to give an opinion saying that this actually works. So those types of transactions underscore the practical importance of precedent. You can only provide the advice if you can say with certainty that the court is likely to construe this warranty in this particular way, or that the court is likely to construe this expression in this insurance policy in this particular way. But that depends on the consistency with which those judicial decisions are followed. Without that, everything has to be decided de novo, and of course that's a recipe for confusion and for uncertainty. So that's the greatest advantage of judicial precedent. Does it therefore follow that in continental systems where the law is said to be exhaustively stated in the code, they have no security of transactions? Not necessarily. But of course, in those systems, they rely less on what the courts say, and they try and structure their transactions to fall within the letter of the code. But of course, there are also decisions in those systems, but those decisions are persuasive. Now, what about the disadvantages of judicial precedent? One of the disadvantages of judicial precedent, I will come to this later, is that it leads to uncertainty. On one hand, we talk about certainty, we trump certainty, but on the other hand, excessive creativity leads to uncertainty. If you've litigated election dispute in Nigeria, you will know that really is uncertain. And we'll come back to that later. So let's leave that, not anticipate it. But it does lead to uncertainty. That's the first point. The second point is that in a constitutional democracy, you could regard judicial precedent as somewhat unconstitutional, because the judges are supposed to state the law. They're not supposed to make them. And when we look later at the concept of prospective overruling and the declaratory theory of law, you will see the pretense of the judges supposedly stating the law as opposed to actually making the law. For the most part, people regard judges as actually making the law, and that is what they do in practice. They say so, they want to adapt the common law to prevailing socio-political conditions. And so the law has to grow in an incremental way. But by growing the law in that way, it's said to assume a lawmaking function as opposed to simply a law interpreting function. Thirdly, judicial precedent could impose judicial values on us. Because after all, when the National Assembly wants to make a law, they consult. Their consultation can be inadequate, but at least there's some pretense to consultation. They can give you a bill and say you have a week within which to respond. But in the case of judges sitting in chambers, they're not consulting anyone. They're like journalists who purport to express public opinion, whereas they're expressing their own opinion. Well, these judges sit in their rooms and decide this is what public interest requires today. This is what public policy requires. And so to that extent, the judges can impose their own values on us, which are not supported by any empirical evidence. And finally, the final disadvantage, judicial precedent can lead to rigidity. In Nigeria, in Nigerian legal practice, one area where we have seen this rigidity most is in some case called Okafor and Nweke. Very interesting case that a process, a legal process, any process, an originating process, a motion, rabbit, must be signed by a legal practitioner. And that if it is signed by the firm, Fidelis Audita & Co., which has just one practitioner, Fidelis Audita, the process is invalid because Fidelis Audita is a legal practitioner, whereas Fidelis Audita & Co. is not a legal practitioner. So you ask yourself, this is balls aching. What on earth is in the head of a person who is coming up with this distinction? But the point has been argued at length, and the court has refused to change it. But more importantly, is the case itself even correct as a matter of law? Forget about the policy issues, whether there's a distinction between Fidelis Audita and Fidelis Audita & Co. Is it correct as a matter of law? You have to ask yourself, for an originating process, who actually issues an originating process? Since when, which lawyer has ever been able to issue an originating process? What we do as lawyers is that we prepare the documents. They are all draft documents. We take them to the registry, and that taken to the registry is an application to the registry to issue the process. All the High Court rules provide that the process is issued when it is sealed and signed by the registrar. And until that happens, that is just a draft. And it is when it is sealed and signed that it is entered in the course book and allocated a case number. You cannot allocate a case number to your draft in your chambers. You cannot put the court seal in your office. You cannot impose the registrar. So in truth and in substance, the process is issued by the court. And this is especially so in relation to originating summons, which are required to be signed by the judge, not just the registrar. But notwithstanding all these, if the application to issue is made by Fidelis Audita & Co. and not Fidelis Audita, the entire process is said to be a nullity. And you know, Nigerians, we love catchphrases and we love cliches. And then they will tell you, you cannot place something on nothing, which begs the question, what is a nothing? But you know, like every catchphrase, it's just a place to take refuge. It doesn't encourage any analysis. They tell you, oh, UAC at Mark 4, you cannot place something on nothing. It cannot stand. Well, that all begs a whole series of questions. When is an originating process issued? And so that is one of the problems we have. And we're stuck with this. It has no functional utility. It has no even doctrinal utility. So you don't understand. The only reason why you see it is because when you look at the general forms which are set out in the appendix, which are simply guides, because those general forms tell you that they can be departed from, they can be modified. But those general forms provide that this writ was issued by. But clearly, that is erroneous. In the case of originating summons, they say this summons was taken out by. But clearly, that also is erroneous. Well, how can we then, in an unthinking way, allow the forms to dictate the outcome of proceedings? In some cases, where you have already spent 10, perhaps 20 years, the proceedings are set aside because you have not signed your form. Now, in relation to, so that's one of the problems with your precedent. It's said to be a great thing. But like most things, the central parts are very clear. The devil is in the detail. In order for precedent to apply, you need 4 ingredients. First, it has to be a proposition of law, obviously. Secondly, that proposition has to form part of a ratio of a case, not just a gratuitous expression of opinion. And thirdly, it has to be decided by a court whose decisions are binding. And finally, there must be no distinguishing features. So if any one of those, as Nigerian courts say, these requirements are cumulative. If any one of them is missing, then you don't have a binding precedent. So if, for example, you have questions of fact, they don't form any precedent. But of course, often, the distinction between law and fact can be art form, as those who have litigated mixed issues of law and fact will tell you in the appellate courts. But generally, we'll say something is a fact if it depends on the credibility of oral or documentary evidence produced. Whereas if it is all depends on inferences to be drawn from other circumstantial evidence. So those are said to be questions of fact. Anything else is a question of law. If you're trying to construe a contractual provision, that's not a matter of law. It's just a question of what is the intention of these parties. And the process of construing their intention is simply ascertaining facts in relation to that contract. The characterization of the facts themselves is a question of law. So you say, okay, so you want to determine whether someone has a lease or a tenancy. You have to construe to see the rights and obligations which are created by the document. That first stage, which is ascertainment of intention of the parties, is entirely a question of fact. What do they intend? But once you've ascertained their intention, the characterization of that intention is a question of law. So in the same document, of course, there are 2 stages. The first stage is one of fact. It doesn't bind anyone. The second stage is one of law. So also when you construe a statute, they say the construction of a statute is a question of law. As regards the ratio, there are so many nuances. I'll leave that. And just to point out that if it is not part of a ratio, it can become persuasive. And there are a number of examples of things which are not the ratio, but which have become great sources of law. I'll give you 3 examples only. The first is a great case of Headley Buying, which imposed or recognized for the first time liability for negligent misstatement. In the case itself, the proposition that the person can assume responsibility towards a third party, extending Donoghue and Stevenson, was obiter, because on the facts of the case, the House of Lords found that there was an effective disclaimer, that it disclaimed responsibility. Therefore, all those wonderful opinions expressed were obiter. But the obiters have become law. So also in Rylance and Fletcher, it was obiter. And more importantly, coming home, the great case of Madukolo and Nkem Dilim, which every practitioner knows, because we'll come back to that case. We all love it, the 3-pronged test, the Madukolo, where Bayramian said, a court has jurisdiction if it is constituted as to its members, and if the members are qualified, and if it falls within the subject matter and there is no feature which deprives the court of jurisdiction, and thirdly, that there is no condition precedent or something else to be satisfied. But all those things were, because in the case itself, the case was remitted to the native court for rehearing. And there was never any issue whether the native court was competent. The issue was res judicata. So the entire opinion, which has dogged Nigerian law, is obiter. But it has become a ticking-the-box exercise and has produced a generation of very lazy and unthinking lawyers. But we're going to get to that. We're going to get to those features. Now, I want to look at precedent in Nigerian courts very quickly so that I can give the discussants the opportunity to come like me to rabbit on a bit. I'd like to look at three aspects of the application of precedent in Nigerian courts. The first is what I regard as precedent and jurisdiction. And you shouldn't blame me for that. I'm really very traumatized by the invocation of jurisdiction in Nigeria. Because having litigated for more than 30 years in England, I haven't come across jurisdictional issue more than once or twice in 30 years. But every day in Nigeria, I'm confronted by jurisdiction. In fact, when I went to court on Tuesday, I had 8 preliminary objections against me. So I told the judge that this is a season of objections. Here I am with a simple case, and I have 8 objectors. No one wants to come for a trial. But we'll get back to that. So precedent and jurisdiction. The second is what I regard as, describe as precedent and prospective overruling. And finally, of course, precedent and conflicting decisions. In relation to precedent and jurisdiction, I would like to look at 2 aspects of precedent and jurisdiction. The first is the definition and allocation of jurisdiction between the federal and the state courts, a matter which produces almost 40% of all appeals coming from the Federal High Court. The second is this great case of Madukolu and Nkemdilim. But let me deal first with the definition and allocation of jurisdiction. Of course, in every system, every federal system, the definition and allocation of jurisdiction between federal and state courts is an important one. And in Nigeria, we find that definition partly in Section 251, subsection 1 of the Constitution of Nigeria, 1999, and partly in Section 71 of the Federal High Court Act. But they are very similar, almost identical. And Section 251 itself reenacted Section 230 of the Constitution of 1979. But what is the source of the problem? It lists various matters that you might regard as subject matter jurisdiction. The real problem with Section 251 and Section 7 of the Federal High Court Act is the proposition that it doesn't apply to simple contract matters. You have to be really clever, not just having a big brain, really clever, to know what is a simple contract. And I'll give you some examples. Section 251, subsection 1E, deals with matters arising from Companies and Allied Matters Act and the operation of that. So, let's look at 2 examples. If the question is whether a director has invalidly removed from office, you say that is an aspect, because directorship is dealt with in the Companies and Allied Matters Act. That is a matter within the Act. But if that same director is complaining that at the time of his removal, his employment contract with the company as executive director or managing director was terminated, the court says that is a simple contract. And because it's a simple contract, now you have to go to the National Industrial Court. But you're also complaining that you were removed as a director, and you're supposed to do that in the Federal High Court. So on the same facts, what they call cause of action, you are required to go to the Federal High Court to complain about removal of director, and you're required to go to the National Industrial Court to complain about termination as an employee. But it gets even better. If you apply to a company to subscribe shares, and the company gives you shares which turn out to be lemons, you can rescind and go to the Federal High Court and complain because the allotment of shares is a matter arising from the Companies and Allied Matters Act. But if you bought shares from me, you have the misfortune of buying shares from me in a secondary market transaction, shares which have already been issued, they'll say, well, that's a simple contract matter. Why are you troubling the Federal High Court? You bought shares from Fidelis. Go to some court and sue him. But it's even better where you have a rights issue by a company, and then as part of that rights issue, you then you buy from another shareholder who took up their rights. So the company gives rights shares to everyone, but in relation to the one I bought from her, I have to go to the other court because it's a secondary market transaction. So also, you can see in relation to oil and gas, mines, minerals, which has generated a lot of controversy. If your complaint is that your oil prospecting license has been revoked, or your oil mining license, oil mining lease has been revoked, or is not renewed, you can go to the Federal High Court. But if you bought an oil mining license, an oil prospecting license, or an oil mining lease from someone, that's a simple contract matter. I mean, what is a rocket science in the definition? But it's even worse, because in many other systems, once a matter goes to the appellate courts, they won't care where it is coming from. But in Nigeria, because jurisdiction is the lifeblood of litigation, and you have the misfortune of finding yourself in the wrong venue, you can litigate for 40 years and you'll still go back and start again. But no one is asking to what end. What's the point? Because the whole point is entirely pointless. Why are you asking the person to start all over? What is it that is in the Federal High Court? They have ascertained all the facts, they've done all the appeal. Why can't we just get on with it? But we're held by precedent, which says that it's the first thing, it's the lifeblood. So that's the first part that I'm troubled by. The second part that I'm troubled by, it causes me even more trauma. And that is this famous case of Madukolu. But I'd like to start with that by saying that the problem that I have with that area is a general problem I have with many aspects of Nigerian law. And that is the recourse and taking refuge in catchphrases and cliches as opposed to analysis. And you also see that to a lesser extent in the invocation of Black's Law Dictionary. A person is asked to construe Nigerian Constitution. Instead of construing Nigerian Constitution, they are citing Black's Law Dictionary written by an American, Mr. Garnier. Jesus Christ. So when the National Assembly or whoever drafted our Constitution was making it, they had Mr. Garnier and his Black's Law Dictionary in mind. So it is embarrassing when you act as an expert on Nigerian law and you cite Nigerian cases which are supposed to be authorities for certain propositions, but you open the case and find that all they've done, there's no analysis, they've just cited Black's Law Dictionary. And your foreign colleagues are looking at you. What's happening in your Mickey Mouse country? You mean you people cannot even have judges who can analyze what your statute means? You are taking refuge in Black's Law Dictionary. How? How does Black's Law Dictionary help you to determine whether Section 4 vests powers in who it says it vests in the National Assembly, or that Section 6 vests judicial powers in the, but they will take it. Judicial power, according to Black's Law Dictionary, means rat or rabbit. And you're just saying, look, these guys are not serious. Until they are serious, we will know. But coming back to this catchphrase. That's Black's Law Dictionary is one. The catchphrase is the second one. This Madukolu, I love it. But before I tell you my problem with it, I know that as an international lawyer, international investment law, public international law, private international law, there is a crystal clear distinction between jurisdiction on one hand, questions of jurisdiction, and questions of admissibility. The case comes before the court initiated by due process of law and upon the fulfillment of any condition precedent to the exercise of jurisdiction. So if you ask yourself, according to my distinction between matters which affect the power of the court and matters which affect the claim brought before the court, you will see that the first point it is properly constituted as regards the qualification of the members, affects the power of the court, obviously. If you go and get somebody who is not qualified as a judge to sit, then obviously that court has no jurisdiction. Also, if it doesn't fall within the subject matter, then obviously there is a problem. But what about the other two requirements? And there is no feature in the case which prevents the court from exercising its jurisdiction. So you are assuming already that the court has jurisdiction, and you're asking, is there a feature in the case which prevents the court from exercising that? Well, how can that be a matter of the court's jurisdiction? But the third one is even more troubling. It says the case is initiated by due process of law and upon fulfillment of any condition precedent. It is clear that those two matters affect the claim, they don't affect the power of the court. And therefore, they are matters of admissibility and not matters of jurisdiction. And that distinction is very important because whereas jurisdiction cannot be waived, it is statutory and it cannot be subject of estoppel, admissibility is a matter of judicial discretion, is a matter of arbitrary discretion. And we've seen this, for example, in relation to litigation. If you look at Rule 51 of the Federal High Court rules, what I call the anti-technicality provision, it tells you that if there's an irregularity in the issue, so that is what is talking about admissibility. There's some infirmity affecting the claim, not the power of the court. And in England, the courts have applied the same distinction between jurisdiction and admissibility. You can challenge an award made by arbitrators on the basis that it is, the arbitrators lack jurisdiction. But you cannot challenge it on the basis that they did something which is inadmissible. And in 2 cases last year, they confirmed that matters of pre-arbitral steps. So for example, the arbitration clause provides that before you can issue the arbitration, you must try reconciliation, you must try mediation. In 2 cases, one involving Sierra Leone, the court held that those pre-arbitration steps, they are condition precedents, all right, but they go to admissibility, not to jurisdiction. Because they are matters affecting the claim. They are saying before you can assert this claim, you have to go through this hoop. And that is important in Nigeria for people litigating the Public Officers Protection Act, which of course everybody knows when you are suing a government department, that's the first thing they wave at you. But truly, that is a matter of admissibility, not of jurisdiction, because you are saying you have this precondition affects this claim. Before you can bring this claim, you have to have given me pre-action notice. And your failure to do it means that the claim is not admissible. But the inadmissibility has many consequences. The judge can adjourn it for you to give the notice. The parties can waive it. Whereas if it is truly jurisdictional, there is no power to adjourn, to stay, or to waive. But because of Madukolu conflating admissibility and jurisdiction, and because of the judges and the lawyers who want quick fix solutions, no analysis, we now find that everything is about admissibility. Everything admissibility is now framed as jurisdiction, and the law has remained deeply confused to the prejudice of all the litigants. I think my time is almost up. Let me just talk briefly on 2 things. I was going to, if I have time during the question and answer, I might come back to a case called Zakari, which should tell you how Nigerian law operates. But let me deal briefly with precedent and prospective. One of the big debates is whether where a court departs from its previous decision or decides to overrule an existing precedent, it should overrule it prospectively, i.e. with regard to the future, so that it doesn't affect prior transactions. Or is overruling always going to be retrospective? There are arguments both ways. The argument of principle is that the judges state the law. They don't make the law. But if a judge were to overrule and say, this overruling is for the future alone, therefore prospective, that looks dangerously like making the law, as opposed to telling us what the law is. But in addition to that doctrine of objection, there is also the problem that at a practical level, it can lead to discrimination because it means that for the parties before you, they have one outcome, whereas for others affected by the same principle, they have a different outcome. And the law cannot act in that inconsistent manner. And so because of that, the general rule is that overruling has to be retrospective as well as prospective. You declare the law as to what it is. And that is consistent with the declaratory theory of law. So the declaratory theory of law says that the law is what it is. We can misunderstand the law. So when the judge says an offer and acceptance does not give rise to a contract, it's not making new law. It's just correcting our understanding. And because it is declaratory, it will apply both as to future and as to the past. So if you have done something wrong, you lick your wound. For the future, you'll be guided appropriately. And the question is a system based on judicial precedent able to accommodate, in some limited circumstances, prospective overruling, where it will cause great hardship and unsettle a number of transactions which have been carried out on the basis of existing knowledge of the law? And finally, that point arose in a case called Spectrum in 2005. After great arguments, the House of Lords, as they were then, said, well, we'll never say never. We can see some reasons why, in appropriate circumstances, it might be good to overrule as to the future, because although we say we state the law, people also know that we make the law. After all, the common law is judge-made. And because it's judge-made, we should not extend the pretense and fiction too far. We can agree that in some contexts, we're actually making the law. But assuming that is true of common law, can they also do so in relation to statute law? Can they interpret a statute, change the interpretation in a manner which is only prospective, when the power of lawmaking belongs to the National Assembly and not them? And finally, precedent and conflicting decisions. Of course, we all know that. You all have examples of conflicting decisions. I have mine. I did a series of cases in the Court of Appeal, the same Lagos Court of Appeal, 3 different cases, and they came to 3 different conclusions over a period of 1 year. And so you're asking yourself, what is happening? Is it that these judges suffer amnesia? And in 2 of those cases, the panel, there were 2 members, so there was overlapping panel. 2 of the members were also members of the second one, but they gave 3 different decisions arising from the same company within a period of 12 months. Yes, sorry. I said I wanted to finish by mentioning the 4 things that I thought will shape the future of judicial precedent. And I'd mentioned the distinction between jurisdiction and admissibility, the quality of the advocates, and the differences between the older practitioners that we saw in the 80s and 90s and now what we see, cut and paste. And then thirdly, the role of the judges, the recruitment, the promotion, the discipline, and how those things impact. And of course, the big elephant in the room, which is a small matter of corruption, because judges see their roles as personal. Connection, I was mentioning this big statutory litigation where the judge found that there was no contract, but nonetheless directed the DPR to seize 1.5% of the oil block and give to this local person. And then appointed his friend to be the accountant to carry out some audit and directed that they should pay him 150 million. You know, as if the money belonged to him. That's why I said to you that 2 types of cases trouble the Nigerian courts: the big oil and gas cases and the election cases. Everything else is okay. If you steal a chicken, you go to jail. But if you steal your state money, you can hire us, and then you won't go to jail. Not because the law is different, but because the judges feel unable to resist the pressure imposed both by the litigants themselves and the advocates. So when that case, the statutory case, got to the Court of Appeal, the Court of Appeal upheld that, which was very strange. But in addition, the Court of Appeal held that there was a contract. But nobody challenged the finding of the High Court that there was no contract. The appellant did not, the respondent did not. But the Court of Appeal, on its own, without asking anyone to address it, very desperate to get a piece of the action. Yes. Said that there was a contract. So when it got to the Supreme Court said that the case was excessive for its wantonness and perversity and miscarriage of justice. And two out of the three justices of the Court of Appeal were in the Supreme Court. So the fact that they felt that strongly to abuse their colleagues like that, and in fact, the judge who gave the lead judgment was there. And I won't mention the person's name because you're all very familiar with it. But you just see the way that justice is miscarried. I don't know whether they were bribed, but clearly it represented the greatest misapplication of precedent that I'm aware of. Because when the clients came and we advised them and said under Nigerian law, of course, if there's no agreement, there's nothing, you then impose specific performance against a non-party by directing the DPR to seize the oil block. And you ask yourself, how can you advise? Because these people were asking us, but you told us Nigerian law was X. I said, that was our understanding. And that this error will be corrected in the Court of Appeal. And when we got to the Court of Appeal, the error was compounded. So, of course, we then got sacked because obviously we don't know Nigerian law anymore. And you can't blame them. Having lost twice, come on, in a big case where there was over $300 million at stake. And of course, they got someone who won the case for them on those same issues that the two lower courts refused, on the basis that there was no contract at all, on the basis that if there was a contract, it was statute, but all the things that we told them, and they refused. So that is a challenge in Nigeria. And you have to ask yourself whether these conflicting decisions, the fact that they refuse to follow straightforward law, what are the reasons for those things? Is it corruption? Is it because they misunderstand the law? If a person is a judge and does not understand that you cannot impose specific performance against a non-party, shouldn't you remove the person? But if you want to remove them, they will send a GO, and they will send this to you. They will send that. They will go and beg your grandmother. Everybody will come and say, Mabino, leave him. You'll be all right. We can't use this one as a scapegoat. So who do you want to use as a scapegoat? And the system has collapsed completely. And finally, but even in England where they got that, England has moved away from it. Because in England, the way that their own courts now determine whether to enforce a contract tainted by illegality is to ask whether enforcing the claim, which is tainted with illegality, will be contrary to public interest because it will be harmful to the integrity of the legal system. This is not a formula that lends itself to catchphrase. You have to analyze, because it's asking you whether enforcing the claim would be contrary to the public interest because it will be harmful to the integrity of the legal system. And in determining whether it will be harmful to the integrity of the legal system, you have to ask yourself 3 questions. What's the underlying purpose of the prohibition, which has been transgressed, and whether that purpose will be enhanced by denying the claim? Secondly, whether there are any other relevant public policies which denial of a claim might impact on. And finally, to consider whether denying the claim is a proportionate response to the illegality that has been. But instead of following this type of approach, as I said, est topic causa, non oritio actio, importio, what is it called? Impari delicto, portio est conditio defendantis. So, ladies and gentlemen, on that note, I thank you very much for your patience. And
if you are clapping for Prof, you can do better, please. Well done. Thank you, Professor Fidelis Odita, QC SAN. Prof was actually supposed to speak for 2 hours, but he spoke for just 45 minutes. Can you put your hands together one more time? Come on. All right. We have a short presentation from students before we invite the panelists to the stage, but I'll quickly like to recognize the presence of the Deputy Chief of Staff to the President, Mr. Ade Ikpaye. Please put your hands together for him. With us here today as well, I have Dr. Dakpo Olanipekun, SAN. Let's put our hands together. Honorable Justice Dr. R.O. Olukolu is also here with us. Honorable Justice O. Abdullahi is also here. Can we jam our hands? Honorable Justice Adeyemi is also here present as well. Mr. Olalekan Yusuf, SAN, is also here. You're welcome. Mr. Emeka Ozwani, SAN, is also here. Put your hands together, please. Finally, I would like to recognize all those watching online. We're so sorry for the break-in transmission. And I was just telling the organizers that next time, let's have an opening prayer. All the functions we have in Unilag, when you have an opening prayer, they don't obstruct the light. So I mean, I looked in the program, no opening prayer here. Even if you're a lawyer, you need to call on God in whatever it is you do. You agree or you disagree? You agree, all right. So students, can we have you for a few minutes for your performance? And after that, I would invite Professor Agomo to actually conduct the panelists, please. Students, are you ready? Students, are you ready? Multimedia, please, can you switch on their microphones, please? Multimedia, kindly switch on the microphone so that we can actually... All right, students, you can try your microphones now. Please come on stage because of time. Seated here as well, we have the former registrar of the University of Lagos, Oluwarotimi Shodimo Esquire. Please put your hands together for him. Thank you.
Good afternoon. Good afternoon. Original Promise, a 400 level student of law, Faculty of Law, University of Lagos. Thank you. And this piece, my creation, is dedicated to the heroes, the gladiators of law who have returned to bask in their victories, to recollect, to reflect, and to pave the way forward. Thank you. Sorry, can I get it? Wisdom is awesome in print. It's a black pen on a white sheet. It retells the story of how wisdom is awesome. It's a black pen on a white sheet. It tells the story of how the ropes flutter and the leonard rise, the sun sets and the moon shines, and it happens all over and over again. Filtered thoughts and shots of black, mixed white, grey hues, but separate colors, and the glory of it is discovered all over and over again. The fountain is once again opened. We cover hope, all you will enter with the pure, and their homecoming is here. And wisdom flows over and over again. drink from the spring, the is clear. Those called to raise it and clamber from there, ascending to heights only dreamed of by mere mortal, reaching out to those behind them. Gains all over and over. The home comes with great power and great responsibility, the ability to be the custodians of glorious works, and with heroic finesse I see it happen all over and over again, and like a record, it never stops. The great one come to regale us also feet, and with nimble feet they stand to uphold justice. The ones who came before show the way to the now. I walk in their footsteps, stand us to see the Orient and applaud their great homecoming all over and over again. Its law and its justice, their journey into Alia has shown what is clear. Vision of truths, the wisdom of their peers. I sit and soak it. I fear that this will continue and over again. And over again I regard the steps, and I tremble as I watch the great assemble. And if you ask me if I will stand here in their presence, answer I fear will be all over and over and over again. Thank you.
My father taught me that words are like eggs. And just as eggs, when broken, cannot be put back together, once your words are uttered, they cannot be taken back. Perhaps that made me a little bit more responsible with my speech. But most importantly, it taught me, and it exemplified the fact that no right is absolute. And even the almighty right to freedom of expression is no exception to this. My name is Alunga Gloriozio, and in the next 3 minutes, I'll be telling you why control over online information services is a must to ensure public order. Aside the obvious reason that even Article 19 of the International Covenant on Civil and Political Rights outrightly recognizes the public order exception, my argument is based on 3 salient points. FHL, fake news, harmful activities, and the need for limits. Journalists and information experts are skilled in the art of reporting and information ethics. But what online information services have done is given everybody a platform. And with this has come the spread of fake news like wildfire. During the Ebola disease outbreak, news from an unverified source with no scientific backing whatsoever claimed that taking salt baths would magically poof away the disease. This news left so many injured. Also, the American Journal on Tropical Health and Hygiene has stated that 5,800 people were hospitalized, and 800 people lost their lives in 2020 due to COVID-19 related misinformation. And these are just a few instances of many where fake news has led to the death of many. Secondly, harmful activities. The dark web is an uncharted territory, and it is shockingly easy to find websites that promote illegal activities and harmful activities like sex trafficking, child pornography, and even illicit drugs. This has led to an increase in social vices and crimes. If this goes unchecked, it is only a matter of time before our streets are plagued with chaos. And lastly, the need for limits. Online information services are becoming notorious for the spread and inciting of violence. An example of this can be seen in the United States of America during the Capitol riots, where the internet was instrumental in inciting others to violence. There needs to be a form of regulation to curb this menace. Encouraging the spread of online information with no filter whatsoever is a mask through which the true nature of a thing, anarchy, hides its face. Thank you.
Man is born free, and yet everywhere he is in chains. What they call control is what we call an infringement on our basic right to be free. Ladies and gentlemen, good evening. My name is Augusta Chiwubam Njoku, and the topic is control over online information serves the need for public order. For proper understanding of the topic, it is expedient that I explain, that I make some important assertions. The first is that by virtue of domestic laws and International Bill of Rights, every individual has a right to freedom of expression, and that freedom encompasses online interactions. The second is that in a democratic society, the government has power to enact laws that may censor or limit the exercise of this right, and that is for the purpose of maintaining public order. However, ladies and gentlemen, what we have today is that the government is enacting unnecessary and obnoxious laws that aim to restrict citizens from expressing themselves freely. You will agree with me that it is a fallacious judgment to state that control over online information serves the need for public order. I stand gallantly against this motion, and my argument is divided into two. The first is that freedom of expression is confined. Ladies and gentlemen, in the society today, states are now enacting objectionable laws, and all are with the aim of over-regulating social media and the press. For instance, in Nigeria, the anti-social media bill that was introduced by the Senate and supposedly aimed at criminalizing the use of social media to spread false information. However, when the contents of this bill were examined by international human rights organizations like Amnesty International and Human Rights Watch, it was discovered that the proposed legislation is in fact aimed at gagging citizens' right to freedom of expression. It is outrageous. It is clear, ladies and gentlemen, that these legislations have no purpose of maintaining public order. Rather, they are aimed at, they are expressions of government's intention to curtail citizens' freedom of expression. Number two, the regulations are ineffective. Ladies and gentlemen, even in the USA, the Computer Fraud and Abuse Act is struggling to protect citizens from online fraud. Talk more of Nigeria. Many of us are not even aware that we have a Cyber Crimes Prohibition and Prevention Act of 2015. We are not even aware of its contents. And let us even revert our minds to the Twitter ban of 2020, when the president of Nigeria whimsically decided to regulate social media by banning the use of Twitter in Nigeria. Now let me ask a question. To what end? Did that solve anything? No. Nigeria simply downloaded VPNs and went back to tweeting, comrade, no be so. Ladies and gentlemen, in conclusion, we can now see that from the infringement on our right to freedom of expression to the ineffectiveness of the so-called regulations, it is clear as crystals that it is a fallacious judgment and an erroneous fact to state that control over online information serves the need for public order. Thank you.
Once again, put your hands together for that. Well done. Big shout out to the lady that said good evening. When she said good evening, I looked at my wristwatch and I had to correct. So, good evening, ladies and gentlemen. I'd like to recognize the presence of my Lord, the Chief Judge of Lagos State, Honorable Justice Kazim Olariwaju Aloba. Our time is fast spent already. In order to conserve time, we may not be able to take the bow of the panelists I'll be inviting on stage. But quickly, I'd like to bring on stage Professor Chioma K. Agomo. Please put your hands together for her. Also to be on stage, we'll invite my Lord, Honorable Justice Oluwatoyin Ipaye. Please put your hands together. Dr. Senator Ajibola Bashiru. Please put your hands together. The next is Professor Oyelowo SAN. The next is Professor Yemisi Bangboshe SAN. She's online multimedia. Please, we need you to connect Professor Yemisi Bangboshe SAN.
I've been warned not to establish any precedent so that we don't have a conflict and then maybe having set a wrong precedent. Those coming after will have the difficulty or the choice of whether following or setting their own, then confusion continues. Well, I'm standing on existing protocol. We have been fed. We've all been here, so there's no need reinventing any wheel. We have here panel of discussants from the legislature, from the executive, from the judiciary, from the academia. I don't think that anyone here who had listened, whose mind has not been, I won't say agitated, but who will not put on his or her thinking hat to ask yourself, should we allow the status quo to remain? Or is it the time to start and say, we cannot go on this way? Or how do we go about it? We have suggestions how to go about it. And so let's listen from the discussants, 15 minutes each. After that, we're going to take some questions and then we'll wrap it up. I want to challenge everyone, like I said. I was privileged in December, that was December 2nd, was in Abuja, the National Judicial Institute. I also chaired a segment like this, what was the first symposium in honor of the late Justice Nikki Toby, and it was on judicial precedent. And the issue was also raised. What do we do with conflicting decisions? Should we continue to say, I'll stick to the doctrine of stare decisis? Or is it time for us to begin to put on a thinking cap and begin to chart a new course for the judiciary, for the legislature, for the nation? Remember here we're talking about stare decisis and the future of legal practice. The future of legal practice also determines so many other things. We talked about development and all that. If we get it wrong in one area, it's going to filter to other areas. So it's time we get back to the drawing board. Or do we say there's nothing to go back to? But then let's listen to the various discussants. First of all, I'm going to call on Honorable Dr. Senator Ajibola Bashiru. 15 minutes.
Thank you, the chairman, and I also stand on existing protocols. I would say, preface my contribution to say that is indeed a matter of emotion and honor for me to be here today. Somebody who had the fortune of being an expelled student of this faculty and eventually had to come back, complete my degree here, insisting that I must still get my master's education here, and of course, finishing with my PhD at the Department of Private and Property Law. So we say that I'm one of the example of the sterling quality of excellence of the great Faculty of Law of University of Lagos. And I will say that the starting point is that I will express my difficulty in being able to speak on this important topic, having listened to the very elaborate lecture of Dr. Fidelis Odita at QC SAN. At the same time, I think the starting point will be that from the perspective of the legislative arm, the tension will have to be examined first from Section 4 of the Constitution, vis-a-vis Section 6 of the Constitution. Section 1 of our Constitution provides that there is supremacy of the Constitution. And to that extent, any law by subsection 3 of Section 1 inconsistent with the provision of the Constitution will be null and void. Section 4 of the Constitution gives the National Assembly power to make law for good government of the country in matters in the exclusive legislative list and in some matters in concurrent legislative lists, and of course, certain enumerated lists in the Constitution. Section 6 provides for judicial powers of the court in relation to their adjudicatory role. But the first interface will be Nigeria, being a common law country, has adopted common law by which judicial president is recognized, and is recognized not just a matter, not as a matter of stare decisis, non quaeta movere alone, but as a matter of actually judge-made law. So the question is that judicial president itself, will it not be said to constitute an usurpation of the function of the legislative arm of government by which you allow a court to make law? There's no doubt anybody can argue which way or the other. I still thought I got it wrong, but I still look at RWM Diaz this morning, and he said that in reality, judges actually make law, even though they claim that they are not making law. So then the impact of the judge-made law appear to be very profound on the work of the legislative arm, notwithstanding Section 4 of the Constitution. And I will mention about 2 or 3 of such impacts. First and foremost, the court, even though it has said in some cases that we are free as a legislative arm to be to regulate our procedure, but then they have also gone to use their interpretive jurisdiction to be able to bring down provisions of the law that we have made. They have also been able to hold the legislative arm to task as to whether we actually comply with our procedure and we comply with our law. And of course, in doing that, the second question will be, in the exercise of that interpretative jurisdiction, are they really capturing our intention? Because usually the mantra will be, we want to discover what is the intention of the legislative arm. When we are taught that, I thought it's something that is easily decipherable. But being a member of the upper legislative chamber in Nigeria with 109 legislators, and we are making law concurrently with a 360-member House of Representatives, what is really the intention of this about 400 and something people in making a provision? So in any event, the reference to the intention of the legislator apparently, as alluded to by Dr. Odita, is actually the intention of the particular judge in question using his own objective or subjective disposition in the contest. Another issue that caught to mind, and the essence of judicial precedent, is that when we make law and certain words have been interpreted judicially, and those expressions have been put in the legislation, the question is that the expectation will be that there is some certainty as to the use and the interpretation to be given to that word. But when other decisions now come forward and now give possibly expanded meaning to those legislation or not even possibly intended meaning. For instance, in the case of PDP and INEC, where the decree referred to death in the case of somebody being appointed, being elected as a governor, then this governor of Adamawa State, Atiku Abubakar, was nominated to be vice president of President Obasanjo, and then he had to leave. Then the Supreme Court, very interestingly, now gave an extended meaning of death to mean to disappear, vanish, and not to be available. In that regard, are they really talking about intention of the legislator, or what are we really talking about in that regard? And that brings to the question of a sociological perspective to the problem we have in judicial precedent. Yes, problem of conflicting decisions, but we must probe what is really underlining this conflicting decision. Is it really a case of lack of understanding of the concept of judicial precedent, or a case of convenience to really adapt and apply law in the circumstances that some other motive apart from law is actually in question? I've been a counsel before an election petition tribunal whereby upon tendering certified true copy of electoral documents, the refrain of the judge, the chairman of the panel, will be, it is straight law that certified true copy can only be tendered with the consent of the opposing party. And that concern is, I heard somebody say, there. Of course, we have to probe whether it is actually trite law. The trite law that we discovered was that there have been communication, regular telephone communication with the chairman of that tribunal and a leading counsel in that case. And some of us had to take it up, wrote to the NJC, and appeared before the NJC about 3 times to establish that telephone communication. The NJC phoned in our favor, but they gave the judge, the chairman of the tribunal, a pat in the back. He was only asked to retire. That takes me to the question of that. What we are saying here, no matter what erudition, what program we put in place to ensure that we address the problem of judicial precedent and certainty of our law, when established corruption cases are treated with levity and with a pat in the back, then there's no impetus to serve as deterrent in such circumstance. Eventually, the senior advocate that was involved was also let go on the technical point as to the irregularity or otherwise of some members of the panel of the NBA that tried the particular senior advocate of Nigeria. So the question of impunity and the question of lack of seriousness into discipline, and even in terms of, apart from judges, legal practitioners. I remember in the law school, we were taught professional ethics. We were told that when you even have a case that is detrimental to your case, you have a duty as a counsel to bring that case to the attention of the court. Then what you can do, your skill as a lawyer, will be to distinguish that case or create some fundamental exception, urging the court not to follow it. But what do we see now today? People are aware of decisions that are against them, and they hide those cases. And closely allied with this is the bastardization of the law reporting system in our jurisdiction. When we were being taught law in the faculty here, I remember vividly, even at the level of the High Court, the note of Professor Akonki is replete with cases that are reported from the cyclostyle High Court judgment of the Court of Lagos State, which make profound pronouncement on issues and evaluation of evidence. You also be able to see articulation of argument of counsel and even the way and manner the judges have done. But what do we have today? Since 1985, and I'm not referring to any particular law report, what we have is a cut and paste reporting without any distillation of the ratio decidendi in that case. And you now see somebody in court, when I was in active practice, we say ratio 15, ratio 20, ratio 30. I still look at what Daya said. In fact, it's even debatable whether there can be 2 or 3 ratios from a particular case, but we have ratio 36, ratio 37. So the quality of our law reporting system is also doing a lot of damage to judicial precedent. And of course, what we were taught is that the two building blocks of judicial precedent is one, the hierarchy of courts, which has to be settled, and of course, law reporting. Then you also look at even the deficiency in the law reporting that we have. I think it has become more of a commercial enterprise rather than something to aid the work of the profession. You see cases on mundane and rather very, if I may use that word, pedestrian, being the content of a full law report. You will not see a report that shows how the new reported law has impacted on the existing law, in what way it has made an innovation in the existing law, and in what way has the court applied existing precedent. So the law reporting system is a major problem for us. And I believe also that as a country, we should possibly look at official law reporting for our courts, empower them to be able to do so, and then look at what are the attributes of good law reports. I remember when we read QB, KB, Chancery Division law report, even when a counsel lost a case, you see plausible arguments that have been advanced, properly articulated, and you may even use it in advancing argument to be able to do so. So the question of the problem of law reporting, content, quality, and merchandising of law report is a major issue that has to be addressed in that context. Then the question is, we have said we should apply stare decisis. I say this at the risk of being said to be abrasive. I doubt whether many of us practitioners, as legal practitioners and judges, even understand the clear requirement for stare decisis, and whether we know the interplay between ratio decidendi and obiter dictum, and whether we know what actually constitutes substantial materiality of fact that will grant the application of a set of law to be able to come to ratio decidendi. And just as we have said, you see a situation like has been given by the keynote speaker of a dictum in Madukolo and Kendilim being raised to the level of even legislation. Because when you begin to now make ticking, 1, 2, 3, 4, it's like you are talking of ingredients of criminal offense, and whether those ingredients are there, if they are there, then you have committed the offense. So the elevation of obiter dicta to the level of judgment of the court, and the canonization of obiter dicta of court to the level of legislation is one of the major problems that we have. And of course, we must tie this to, with respect to our teachers and the Nigerian Law School, inadequacy of our legal training. When I was serving as a commissioner, I was a pro bono teacher at a university. And I discovered, and sincerely say so, and I put it as a challenge to many of us here, that our curriculum of law is actually outdated. We are not teaching our students what they need to compete favorably in international markets to be able to do so. Yes, in the 70s, and early 80s, when we were being taught hire purchase in commercial transaction. My father was a motor dealer and a hire purchase and a transaction dealer. But when I was to teach commercial transaction, I went to research in the law report, and I discovered that for almost about 17 or 18 years, I can't find any reported case on hire purchase. And today, hire purchase teaching is still part of the curriculum of our commercial transaction. Then I asked myself, what of equipment leasing? What of operational leasing? What of finance leasing? Which are actually the key things that we need to teach our students. The same thing also, we teach legal system, legal method. Yes, it's good to do so, but I think even at the advanced stage of our learning, legal method, legal system, concept of judicial precedent, legal research should be part and parcel of what we teach at every level, from level 2 to 5. Of course, we have an overburdened judiciary, and some of them are self-inflicted. When you have an overburdened Supreme Court that is already giving 2024 date, already taking additional jurisdiction about who becomes governor, and also the inconsistencies in the jurisdiction as to whether you're elected as a senator, the upper court is the Court of Appeal. But pre-election matter in relation to your election will go up to the Supreme Court. Serious absurdity in terms of jurisdiction. So we have an overburdened judiciary, which also has a problem of even no incentive for research, no incentive for dedication, and we have a situation whereby close to 2 decades, possibly, their remuneration allowances has never been reviewed. Then, of course, political influence and corruption, and that is because we have a political economy that is actually, if I may say, and don't quote me as a senator, political economy of state robbery, because everybody looks toward the state for personal resources and aggrandizement, whether in the private or public sector. So when the stakes are high, then judgments are conflicting, decisions that appear to be white and black become blue and white, like that of Emeka, Senior Advocate of Nigeria. Then you also have misapplication of judicial activism in a certain instance. In certain instances, because of the tendency to appeal to the masses, because of the tendency to see that you want to expand the scope of law, then judicial precedent is misapplied in order to be able to do so. So for me, as a legislative arm, we are burdened for the fact that we are not sure in what way our law will be interpreted and in what way will be applied. But I believe that there are certain reforms we need to be thinking about. We need to deepen our legal education. We need to address overburdened judiciary. We need to expand the capacity, particularly of the intermediate court, the Court of Appeal. I hope the proposal to have minimum of 100 judges at the Court of Appeal will see through the recent constitutional amendment. Then on the issue of jurisdiction, I think there's a need, it's high time we have a voluntary transfer clause in our constitution to allow judges to be able to transfer cases to appropriate venue rather than strike out cases on that basis. That will address the challenges that we have in terms of conflicting decisions, particularly on the issue of what they call technicality and decision for jurisdiction. I thank you for the opportunity to be part of the dialogue.
Thank you very much, Honorable Senator. The tempo continues, getting higher and higher to a crescendo. I'm sorry, that's what comes to be when we need to manage our time. So subsequent discussants, 10 minutes. Thank you. Go to the executive, our very own Professor Oyelowo, SAN.
Thank you very much. Well, in the light of the fact that the time has been further reduced, as a matter of fact, I was cracking this joke with my wife yesterday when I was preparing. I said, you spend hours preparing, and then you get there, they will tell you 30 minutes. Then it goes to 15 minutes. Now it's 10 minutes. I hope it doesn't get to 7 minutes or 2 minutes before we leave this place. I won't stand on existing protocol. I'll just hang the protocol and go on what I have to say. I'll start from where the distinguished senator started and be more radical in my own thoughts. I believe if you want to deal with anything, you have to start from the foundation. Who are judges? Judges are legal practitioners. Is that also who are elevated to the bench? And who are lawyers? Lawyers are law students who are certified to practice the art of lawyering and apply the skills. So bottom line, you ask, where do we recruit our judges? Is the process producing these judges the same as it were during the time of those judges that we are celebrating? If you ask, for instance, how many law schools did we have in those days? And even when we started, did we even have law schools? So for me, from a federal point of view, I think we are over-federalizing the teaching and education of law, and we need to arrest it. The first thing we need to do is to scrap the system of the law school. Scrap the law school. The law school ought to be scrapped because nowhere will anybody spend money building institutions where a set of people will employ themselves and where people will be fighting on the location of law school when you want to produce serious-minded people who will be able to deliver on skills. By the grace of God, I was a Fulbright scholar, and I had the opportunity to sit for the State Bar of California. There was nothing like law school. You go to the School of Law, you are taught criminal law with CrimPro, you are taught civil law with all this, so you are taught jurisprudence, you are taught ethics in the university. And if you think you want to practice law apart from the knowledge of law, you have a body that does the examination and certification. You don't have to go to Abuja or Ikiti or Bayelsa to be kidnapped or anything. And it is done in other professions. So why are we living, and even in these days of virtual teaching, we do everything virtual now. So why must I go to Bayelsa State and start lobbying as to where somebody wants to go, and it becomes a privilege whether you are in the law school in Abuja or law school in Lagos. If they don't scrap it, they should go virtual, so that everybody can do it in the confines of it. So anything you need to know, all this fork and knife, learning to eat and all that, they are just old school stuff. The foods are not even as, entertaining as before. That's one. Then the second thing about the issue that was raised by Prof. with respect to the blurring of the distinction, it has become an unending, struggle to define what, stereotypes are. So I decided to do a comparative study. Look at Ghana, look at South Africa. I didn't look at America or England. What are they doing in our neighboring African countries? Can we learn something from them? Can we even learn something from other people who have been able to evolve in a way that they are not bound and they're able to develop? Because there is an obvious conflict between progressive thinking and development and the idea of stare decisis. Because stare decisis says, somebody has thought for you, you don't need to think. And that is inherently contradictory to the nature of man. Why must I not think? In your Rawani, Sholori Mejini. So you are in the Supreme Court, yes, you have experience and all that. But experience that you have as you are going and growing up and going up, your experience is even out of touch with the experience I'm having as a current judge at the High Court. So there should be a way, and the way it's been done in some jurisdictions is to introduce the concept of black letter law, where the law is not only limited to the jurisprudence dictated by stare decisis, but take cognizance of evolution. So for instance, most of you have read about the case of Roe v. Wade, about abortion, where they were able to find in the Constitution of America that there is the distinction between the right to the body of the woman as opposed to the right of the unborn child. In the year when the American Constitution was written, if anybody has said that kind of thing, he will be killed, because it will be totally unacceptable, because he will be deemed as somebody that wants to kill a child. But when the judge was looking, he said, yes, if you bring these old founders here today, there will be in their mind the reality of the compelling reason to look at the rights that are competing between that of the mother and that of the child that is carrying. And Roe v. Wade started, not perfect, so you had all these trimester, so you jam old, you jam new medicine, trimester and all that. This idea of limiting and not just thinking beyond stare decisis is inherently incompatible with human nature, to the extent that people will always find distinction, people will always find reason to say that this is not ratio, this is orbital, this is not orbital, this is just a saying by the road. And as long as people can do that, they will find a way. So how do we do it? Let everybody know what is the ratio in a case. So when the Supreme Court gives a decision, state that this is the ratio, and let that ratio be captured by a body that continue to do what we call restatement of the law, so that the law is restated. So when it comes to a conflict, for instance, between the administration of criminal justice law and the evidence law, it will not be determined differently by the Court of Appeal in Lagos from the Court of Appeal in Abuja. And that's exactly what happened. Because the Court of Appeal in Lagos, in looking at confessional statement, applied, the administration of criminal justice law. And they applied the principle that says that if the root, the poison tree doctrine, that if the root is bad, then the fruit is, poisoned. So if you don't have free confessional statement in accordance with the administration of criminal justice law, the whole thing will be declared null and void. And in the case where it happened, it was so silly because the person was actually caught a thief and all that. He just said, my lawyer was not there when my statement was not made. And the case was thrown out. So of course, the other jurisdiction said no. Where there is a conflict between an adjudicative law and a substantive law, the one that will prevail is the one that will apply. And in this instance, the Evidence Act should apply and not, totally the administration of criminal justice law. So we have tensions. And when we have tensions, it's only in the African setting that people don't go directly to the problem. Because we don't speak directly to each other. Even parents don't speak directly to us. You have to decipher what they are saying. And when you get it wrong, he didn't directly communicate with you, but he still exercise the right to discipline you. And that is what the law does. They will say ignorance of the law is no excuse. Even the person who is doing the law self is ignorant. How many people in the house, pardon to the doctor here who knows what he's doing, knows what they are doing in the National Assembly who are making the law? So, in actual fact, you got it right, Prof, because even as late as 2021, last year, there are cases that suggest that we are never going to get out of this. And this case I'm going to cite because all of you have to read it. And you will see the sheer silliness of the majority decision. Silliness, quite crass silliness, basing a decision on technicalities. And that's the case of Ode against Alaga. Thankfully, the dissenting, judgment was, eloquently articulated by one of the graduates from this, university. And in that case, a man won election. They took him to tribunal. Oh, citation, you want citation. I'd forgotten, I've been away from the classroom. So don't mind me. 2021, 22 Weekly Report of Nigeria at page 1. 2022. 22, that's Weekly Report, not part. Ogumiju Urida at pages 85 to 89, and Muhammad at 73. So he wins election. They take him to tribunal. They take him to tribunal in Cross River State. All of a sudden, somebody starts an action. He didn't serve him notice. He didn't do anything. He gets a judgment against him. So he only hears about it. The man is in Abuja, working in Abuja. He wasn't served. And he hears about it, that, oh, you are about to be, removed. So he quickly instructs the lawyers. So the lawyers, in the hurry, they filed the action. The parties knew they were served. And then a preliminary objection was now raised. Okay, a preliminary objection was now raised that the service was not correct. So, of course, once the preliminary objection was raised, the party went to court and sought leave and got the leave, and they were properly served. But when they got to court, the court said it has to do with jurisdiction. And the jurisdictional, it had nothing to do with jurisdiction. It was just technical justice that defeated substantive justice. And that is what we cannot be saying as part of stare decisis. And of course, you have spoken a lot about conflicting decisions of the courts. And here the executive is really interested. Because whether you like it or not, the stakes when it comes to election petition are high. And if there is no straight path to justice, the crooked path will be told. And that is the big elephant that they say is the small elephant, corruption. Because in election petition, even lawyers, whether you know it or not, is a season for harvest for lawyers, for bumper fees. So the whole system, and the person who is paying the money, he knows. He pays the lawyers, he pays the adjudicators, he pays INEC, he houses them, and you think when the stakes are that high, you don't need to let everybody know that these are the rules that apply. We need to do something about it. Then, of course, when we look at all the cases, let me just, since you have cut me some slack. So, when you look at all the cases from Ondo, I have them all prepared there, but I'll just count through them. The Jegede and Akere Delu case, the Bayelsa case, and in fact, the Bayelsa case is interesting because even the Supreme Court, who could have subpoenaed and know that they were human beings, became cross when they were being told to correct themselves. Senior lawyers were fined, which has never happened in this summit. And that tells you something of the intolerance sometimes that comes about those who sit in these high places. We are all humans and fallible, and we must admit when we commit an error and do the right thing. Because those senior lawyers were rebuked, not quite far some weeks ago, we had the judgment about Monson Motors and that bank. And that is based on the same thing that those lawyers did that they were fined. Conclusively, I'll look at the reform proposals. One, I think we need entrenchment and fostering of judicial ethics and values that will address the various factors. And I believe when we start teaching ethics in the university and not you wait till law school where you don't even know where you are sleeping. Somebody is teaching you ethics. You just want to read it and pass, and when you leave that place, you don't remember again. Then you also have, we need meaningful autonomy of the judiciary. Thankfully, we are working on autonomy of the judiciary. But more importantly, we need sanctions. You know, iluti osofin kuseshe, owotobadeshe lobage. Where there is no law, there is no offense, and it is the hand that sinneth that will be caught. So if you don't cut the hand will keep on growing longer and be restricting further beyond where it should go. So we need sanctions not only for judges, but also for lawyers. We should also think about dealing with the problem of corruption in election. Take it out from the judiciary. Let's have constitutional courts that is not made of only lawyers, but made of people of integrity, and let them be tenured. You serve there for 4 years. If you do good, you have a second year. If you don't, you get out. And let's have clean system of education that you know. And lastly, if I don't say this, I'll be doing disservice to myself as an Attorney General of a state. There is over-federalization of our judicial system. We must, in thinking about reforms, always think about the sub-national groups that make the state. If you are thinking about increasing the number of courts of appeal people, think about establishing court of appeal in the state so that there won't be many cases going to those places. Thank you very much.
Thank you very much. Thank you. I know my brother, it would say 10 minutes. In fact, it took 17 minutes. I know my brother. And so we'll move on to the judiciary. Honorable Justice Oluwatoyin Ekpaye.
Good afternoon. Good afternoon, everybody. Although I am already sitting on the existing protocols, I would like to slightly modify it by recognizing the presence of my Lord, the Honorable Chief Judge of Lagos State, Honorable Justice Kazeem Olanrewaju Alugba. I would also like to say that we've all listened, at least the majority of us were in the hall at the time the lead speaker presented his paper. If the keynote address were to be a precedent cited before me, I can assure you that I will not have any cause, ground, or reason to deviate from it. I am bound by everything that has been said, and I will hereby give judgment in favor of claimant Odita. Thank you very much. This has been a great homecoming for me as well. I think I first strolled even into this campus sometime in 1976, 18-year-old, fresh from the high school, wondering what is next. But I can say that 40-something years down the line, all that is now history. Many of my colleagues are here from the judiciary, and I recognize every one of you, my lords. I'd also like to state that I also started my career as an academic. In fact, when I totaled it and I was sharing with Professor Oshikpiton, I had spent 17 years in academia before I was invited to the bench. And one way I thought I was going to be pursuing the chair, but they said the bench is bigger. I don't know whether that is true. Having said all of that, I think that my own perspective, given my brief, is that I should talk about what then happens in the courtroom. And I think that the starting point would be, if we don't have the doctrine of stare decisis, binding precedents, how would we ever cope? In the Lagos State Judiciary, for example, 7,000 cases are filed every year. The Lagos State Judiciary is the oldest judiciary, is the largest judiciary, is the busiest judiciary, and I dare to say, the brainiest judiciary. My lord, is that not true? So how would we ever cope if 7,000 cases are coming in every year? And so in 2 years, you have 14,000 cases. Meanwhile, our full complement of judges, I think we're about 67, pushing 70 now. But we will never be able to accomplish the matter that is set before us, delivering justice to the people. And we would then have to find ourselves bogged down with that famous phrase. Professor Odita here doesn't like cliches, but justice delayed is injustice delivered. That's my own coinage. And so the doctrine of binding precedents, I think it's a welcome idea. The common law English jurists who developed it, they knew what they were doing. And if we didn't have it, I don't see any way out how we can do better. Now, it may have its own problems. There is no doubt about it. Some of which we have heard. The rigidity, perpetuation of injustice sometimes, before the case, is reviewed again by the most apex of the courts. And, I've also heard somebody say that, it doesn't allow you to think. Well, I don't know if there's any judge that does not think. Me, I think. I am constantly thinking. I even go to bed. I am thinking of the cases. I am constantly in the study, reading this and reading that. So, I do not think the time is right yet for us to throw away the baby and the bathwater. Now, quite a number of things can still be done to improve on the situation. I have said that the judiciary is overburdened. How then do we have diversionary measures that would take away disputes from the courtroom? In Lagos State, we tried a number of things. We had the court-connected ADR center. It was a top battle to get lawyers to buy into the system. We introduced mandatory ADR for some, special types of cases, which from the registry we screen it into ADR, and you have to go to ADR compulsorily. In spite of all of that, it didn't reduce the number of cases still coming to the courts. We tried pre-action notices that, okay, before you even take out a writ, go and take certain steps to talk to your adverse party. Tell your adverse party what would it take to settle this matter. Do all manner of types of things, write letters, but they still come back. We wrote them a letter. They didn't answer us, therefore we're already in court. And it's like, they just, I don't know the kind of word I am to use, but if I to use it, I think that somebody would probably slap me with a writ as well, and I'll have to go and get another senior advocate to come and defend me in a defamation case. As judges, we are on the lowest rung of the judiciary ladder. So when the Supreme Court coughs, we too, we have to cough exactly like that. When the Court of Appeal also coughs, we have to follow their own precedents. It doesn't necessarily make the work easier. It doesn't necessarily mean that we're not thinking. Because you see, binding precedents only work when the facts are exactly on all fours with each other. And so you have to scrutinize. First, you read that precedent that is being cited to you. Then you look at your own case. Are they exactly on all fours? Is there any material way, a distinguishing factor? And so if there's a distinguishing factor, then I do not necessarily have to be bound by something that I consider to be erroneous. And that is where judges then begin to distinguish. Now, again, there is a downside to distinguish. You distinguish too much, you muddle the entire waters. And then nobody has a clue as to what exactly is going on. We don't know, Prof here has shared so many of his experiences, how he would give advice to counsel. Before you know it, the entire situation, another precedent has come out, is different, it's conflicting, and it's getting increasingly difficult to advise and to take decisions, you know, before you get to litigation, because you see, coming to court should be the last resort. Go and do your transaction, go and do your money, understand the law, and, you know, make progress. It is only when things have gone wrong that we then come to court. So we really need to know, what are the courts saying? The courts, by and large, I think we're getting it right 99.9% of the time. There's no doubt that there's still some room for improvement, and it will improve. And I think that, as has been identified by my learned prof at the extreme end, the foundation also has to be looked into. I have spent a little over 2 decades on the High Court's bench now, and I can see a downward slide in the quality of advocates that are appearing before me. Forget about even the grammar and the language. That's not even the issue. But, you know, simple applications. You tell them to proceed, my lord, can I please have a date? It's like, you know, you are ready. They are perennially never ready. All right, we even, to save time, to help us as judges, Lagos State was the one that introduced the concept of brief writing, submit your final addresses. They will submit the final address. Okay, then summarize what you have put down. They cannot summarize. You will be pressing them. I said, you are asking for a relief that depends on the discretion of the court. Then persuade me. My lord, everything I want to say is contained in the written address. And so, you have 10 minutes under the provisions of the law. Say something. Persuade me one way or the other. But they just run away. And I don't know what is going on. A lot still has to be done about the profession, the time for tutelage, whether it has to be extended, whether it has to be formalized. They want to just jump into the... You will be surprised that even the registrar, ordinary registrar, knows much more than a newbie or a new wig. Yes, because there are the ropes you have to learn. This thing will not fall on you. You will not read it in any textbook. But you get it from following your principal to the court, taking notes, learning on it. And then you begin to fly solo. If you don't pay your dues, you will not be successful. I'm sorry to say that. Now, as I conclude my brief remarks, because I don't want Mr. Chairman to penalize me, she's already bringing out her yellow card. As I conclude my remarks, I think it has to be said that indeed there is a big elephant in the room. somewhere along the lines, Nigeria lost its way. Because you see, it is not only in the judiciary or in the legal profession. There's corruption everywhere. The places where you don't expect to find corruption, it is there. Corruption in the judiciary, corruption in the bench, corruption in the profession, corruption in the academia, corruption even in the marketplace. The other day we were told that, okay, there's fuel scarcity. What is the reason for the fuel scarcity? Corrupted oil was imported. Who does not know that when you order for oil, that you give them the specifications, and then you test before you discharge into your own tank farms? And now we're all running around buying from the wayside and, you know, hoping that things would change, they will recall the oil, and so on and so forth. This is just not good enough. Nigeria definitely, we need a new orientation. I don't know where we lost the way, but something definitely has to be done. But these are my few comments, and since we're still here, we will take the questions. Thank you very much.
Thank you very much, my lord. We go to academia. Professor Yemisi Bamboshe, SAN, the Deputy Vice Chancellor. Can we hear you, please?
Good afternoon. Can you hear me? Can you hear me?
Very well, we can hear you.
Thank you very much. It's good to be here. It's nice to see you, Mama, Professor Agomo. And I stand and I adopt, I sit, I do everything to the existing protocol. It's good to be here. And this homecoming is so good for me because in 1980, just like my friend, Milord Toyin Ipaye said, in 1980, I was a fresh student in the University of Lagos. And before I got out of the university, I saw the love of my life. Oh, no, the love of my life saw me. Right? University. He saw me. He saw me. I was reading. Please don't laugh. I was reading. He was the one that saw me. And by the time I was going out, we were dating, and I'm now married. 7 years the line, in 1987, we got married, and I'm married to an alumnus, Honorable Justice Tokunbo Bamboshe, who was ahead of me. So please, I'm not saying that you should not read, please, as you are reading, somebody may be looking at you. Am I talking to somebody? Okay. And I'm also glad that in 2014, I came back on sabbatical. And while I was in class in that auditorium, in the law lecture theater, not the one you're sitting in now, the one inside the faculty, and I was teaching, I told the students in criminal law and the law of evidence, in which I came for sabbatical, and I told them the seat I was sitting, that particular seat I was sitting right in front, because I was one of the EFICOs. I sit right in front, row number 1. If you know that seat number 3, that is my seat. So if you go there, you see my seat there. And I'm so happy to be back. And I'm glad that I have one of my own presently with you in the university, and that is Mrs. Olaoluwatofunmi Bamboshe Ibon, also in the Department of Public and International Law. So to the point now, how does this affect us as lecturers? When you look at this doctrine of stare decisis, which was inherited, and as far back as 1852, even in America, in the Book of Commentaries, Chancellor James Kent was telling us the reason for this underlying rule of stare decisis. And it is to regulate actions, contracts, and for us to be so certain. And that was one of the reasons for this stare decisis doctrine. But when you have something as old as even our grandmother, is it time for us to change? Is it time for us to retain it? You know, if you inherit anything from your grandmother or from your grandfather, it is as old. Does it do the same thing as it is doing? The answer we will see. But if we look at this doctrine, it is said that it is to foster continuity and stability in our law. Yes. And if you look at what the Supreme Court have been doing, why was it that at a particular time, if you look at cases like Mekwenye and the Emirates Airlines, in which the judges at the Supreme Court gave us reasons why we should not deviate from precedent. And if you look at what Ejembi, ECHO, JSC said at that time, let me just quote him. The issue has since been settled. Thus, an attempt to reopen it ostensibly for another panel to render a contrary view is an irritating abuse of process. I think, and I hold so firmly, that this appeal, particularly on issue I canvass therein, is frivolous and a gross abuse of court process. Yes, still going on the doctrine of stare decisis. But now we started having conflicting Supreme Court judgments. And if we listened properly to what Professor Fidelis said, and looking at it, when we have these conflicting decisions, the reasons why they are conflicting or why they are giving us another version of what has been decided earlier, does it make so much sense? Is there so much argument that we can say that yes, just like Justice Ipaye said, is this something that we can say that, oh, there is a radical departure? But the answer is no. But now, on the academia, we do not dispute the fact that no court decision enjoys immunity. We know that no court decision enjoys immunity. But for lecturers and for the law students, I'll just give a scenario how it impacts. Now, it makes teaching difficult. I'm still coming to that because there's a way out of it. To everything, there's a way out. And the issue of conflicting decisions brings about conflicting arguments in class. Now, we're all aware of the case of Donahue versus Stevenson, Ryland, and Fletcher in the law of tort. And we know about Kalu versus the state in criminal law. Those are cases that we can always refer to. And when we're talking about the law of tort. But when things have changed, and it is so obvious that things have changed, we are not disputing the fact that the law cannot change, but there must be very sound arguments. Now, a lecturer comes to class and you teach, you give your students cases, you marshal those cases. You have this very easy and enjoyable task of marshalling the cases, telling them the principles. And then suddenly there's a strike, 1 year strike, 6 month strike. And then you come back and then you start telling the students that what I told you the other time does not apply again because the law has changed. And then another thing happens so suddenly. And then you come again and there is confusion in teaching. Let's leave that apart. You've taught a class. and you've set some questions. And the principles have been well laid. Exams are now coming. The students have written the exams based on that principle. And then the lecturer comes to marking, and the law has changed. Now, the students have written on the old principles. Now you bring out the script. You are forced to mark on the old principle, whereas the law has changed. And anybody who picks it up, NUC now comes in some years later, and they're looking through your scripts, and you are looking at one old principle, and the lecturer looks as if the lecturer is not serious. Marking, setting questions, it becomes so difficult. Now for the law students, I know that I've been given 8 minutes. Students who study law under a confused situation carry on in life with distorted views of law. And this is what students are looking up to. They're looking up to us. They're looking up to the courts. Now we've talked about corruption. We've talked about so many things. We want the law students to go to the bench. We want them to come into academia. We want them to join the executive. We want them to be senators. But when they look at this and there is no predictability, they look at that one is corrupt, one is not serious, one does not know what he's saying, and they become confused. And this becomes a difficulty for law lecturers and also for the law students. But this is not to say that when we do not have predictability, and this is not to say that law lecturers are not supposed to keep in line or up to date with what they are doing. They are. And we should keep our minds open. All the reasons that has been given on why the laws will change, they must be changed based on reasons which Professor Fidelis have stated to us, not on reasons of corruptions, not on reasons that we cannot say the basis, not on the same facts, and then there are reasons why we cannot even say that there is a rationale for teaching. But for the academia, what I should say is that lecturers should be up to date. It behoves on us as law lecturers to harmonize the decisions that are relevant to a subject matter taught at any time and to utilize them. Lecturers were bound to evolve and follow updated decisions. Technology is of much help to us now, and it is of tremendous assistance to us. It is unfair and arbitrary for any lecturer to remain dogged in outdated laws, and we should anticipate change and move on with the current state of the law. As we said, law is dynamic. The Supreme Court cannot afford to be static. But what we are saying is that in any argument with the Supreme Court or which law will want us to marshal to our students in class, we must be able to marshal good points. We must be able to distinguish based on very reasonable points. And we must be able to say that the courts are doing what they are supposed to do, and not because of corruption or any of those reasons that we cannot justify. On that note, I know that there will be questions. I want to say thank you to the organizers of this. Forward to homecoming again. Thank you very much.
Thank you very much. We have listened to the 4 eminent panelists. From the senator, ask the question, is the judiciary not keeping the role of the legislature? When they make their decisions, are they not really making the law? So what is our own role? Because you mentioned the elephant in the house too. To our executive. What I take there is that the separation of powers or functions between the state and the federation is skewed. The federal judges, they have too much. So there should be, call it reorganization or whatever. Why don't we make justice more substantive or more real by creating court of appeal judges? Some of these caseloads and all that will be reduced if you have more at the state level. And of course, the corruption, that elephant in the house is there. Lord, the judiciary is doing well. I'm summarizing. The judiciary is doing well, 99.99 something. That's what. And so there's no need to throw the baby out with the bathwater. That's what she says. Stare decisis is working. It helps us because the caseload is much. But she said that is not to say that there's no room for change. And that elephant in the house is there. To the academics, goes back to the classroom. The doctrine of stare decisis, creating problem as it were, that says, because the rule is supposed to have stability, certainty, which the keynote speaker mentioned. The conflicting decisions of the Supreme Court makes it difficult, just like the keynote speaker said, it makes it difficult for you to be able to advise your client. This is what the law is. So, that makes it difficult. But nonetheless, she said, we have changes. That is the changing times. Technology, not that. So we can't, the status quo cannot remain. If I can summarize it, the status quo cannot remain. Stare decisis is good. But then it presupposes that all conditions for its application exist. And the keynote speaker has pointed out to us that they don't always exist. And the different panelists have also mentioned in their own respective areas where it creates problem, which means that everybody's in agreement that there's a need to have a second look at stare decisis. Like I mentioned, in December, I was in Abuja, the first Justice Nekitobi Symposium, and I chaired the section on judicial precedent. The keynote speaker was the president of the National Industrial Court. And I said they couldn't have made a better choice because this is one area where this issue of stare decisis is playing itself out. We're talking of when you change that's law, if you're changing the concept or whatever, is it with effect to the future, or is it prospective or reactive? I said this is one area where the Third Alteration Act 2010 brought that into the fore. And that the Court of Appeal, seemed Ogabe, I think it was JCA, one of the cases decided, I think it was 2020, recognized that the time has come when you have to take, in other words, look at the decisions emanating from the Court of First Instance, in this case the National Industrial Court, look at it closely before you start talking of stare decisis. Are the conditions the same? This stare decisis you want to apply, were the facts the same? Was it before or after the third alteration? He said, what was it that made the third alteration to come into place in the first place? In other words, what we're saying is that the time has come to take a second look. Because we have been told when you have ratio 1, ratio 2, ratio 3, ratio 3, ratio 4, those of us who use the law reports, you find it's too tedious. When I said to my students, go and read from the law report, and I said, particularly the King's Bench, the Chancery, the whatever, because our own law reports, except those of old Nigerian law reports, the Nigerian commercial law report, if you read them, say the distinction between them and there. So it ties up to that. law reporting, the source of the law, is very important. So we are now dealing with a holistic problem. Remember, we're talking of stare decisis and the future of legal practice. So it ties up not just legal practice, legal development, judicial, economic development, the administration of justice. It's an all-encompassing thing. So with this in mind, the conclusion, that's from my own conclusion, is that we can't pretend that all is well. But at the same time, we are not saying throw everything out. We need to put our thinking caps on. We should not be afraid to think. I remember my lady, Justice Ogunwumiju, she was the one who challenged me. And there was a judgment, I think probably this one where she was the minority judgment, I have to confess. She gave me that, she said, I should go and read it and write an article that they are depending on academia to help them. So they are depending on academia to help them. In other words, it's our responsibility as law lecturers, as those to be able to recite. That's what my Lord Justice Ekpai was saying, and the keynote speaker said it. When the counsel comes and does not present a case, not well researched, or you come with technicality, what is the judge going to decide? So all of us are in it together. And so everybody needs to go back to the drawing board, including our students. When in the days when I used to teach, I'll come to the class, I said, look at you, your pen and paper ready. Look, that I studied law of contract when your mothers were not even born. Not to talk of you people. How do you know I'm not talking rubbish? Exactly, if you haven't read, how do you know I'm not talking rubbish? So why should you not go and read for yourself? So we have is an interactive something. And that they will be able to challenge each other. That we are all students, we are all learners. It doesn't matter the age. That's what has come today. We've come, we x-rayed the issue, we have a problem. How do we deal with the problem? There have been suggestions of how to begin to, as it were, put the situation right. Now we're going to take a few questions from the audience. We don't have much, 10 minutes. 10 minutes, is that okay? Can we take how many? 5 minutes. So 5 minutes. So we are going to take 5 minutes. We are going to take 5 questions, 1 minute each. Okay, I'll have Professor Abiola Sani, SAN. Can I have somebody, please, who will be? Okay. 1 minute. The beautiful thing is that I'm mother to almost everybody. Professor Shikwito, distinguished Professor Shikwito is my son. I can tell him, sit down. Professor Abiola Sani is my son. If he exceeds 1 minute, I can say, sit down. So remember, you have 1 minute. Now, please, before it starts, let's take 5. That's 5. How many? That's number 1. Number 2. Please. It's a 2. Okay. Yes. Number 3. Is there any from the students? We're going to the remaining 2 from the student. Okay. Number 4. What's the 5th one? A student, preferably female. I'm gender sensitive. Where are you? If not, okay, number 5, male or female? Female, where are you now, female? Raise your hand. Okay, okay, 5, number 5, okay, right. Biara, go on, please.
All right, thank you very much. But point of correction, ma. You cannot be Professor Oshikpiton's mother and also be my mother.
Oh, you are my grandson.
I think you are my grandmother.
Yes,
Okay. The metaphor, my hands are tied, you almost think is made in Nigeria, but it's not. In the context of Awolowo's trial, you can give it two interpretations. So I will want Professor Yewo to please speak to this. Then, if we want dynamic changes, it has to move beyond the cliche that law is dynamic. If we want it to be dynamic, we have to leverage statutory changes. We have to, because some of these cases take decades to evolve. Some take 200 years.
Remember, you're asking questions.
So to what extent can we leverage statutory intervention to address the kind of malady such as Okafu and Nweke, for example? Things that annoy us and that blight all our efforts towards progressive changes. To what extent can we use the Senate, the House of Assembly, and the House of Representatives to address the malady?
Thank you. So you're addressing that to Pastor Yewo and
my Senator.
Kiru. Good. Thank you. Number 2.
Thank you very much. As we were speaking, I was trying to put my thoughts together. My name is Tony Adenugba, graduating class of 2001. Thank you. As a trained lawyer, whilst the benefits of stare decisis are lucidly evident, the risks of utilizing it in a dogmatic manner, they're also clear. To me, the best intention of the law is clearly stated in the body of that law. And I work for a frontline regulator in the Nigerian capital market, so I work for NGX Regulation Limited, the regulatory arm of the former Nigerian Stock Exchange. In the market, time is of the essence anytime you're doing anything. And in the course of contributing our quota to national development, I was privileged to participate in the Senate Technical Committee on the review of the Companies and Allied Matters Act, as well as the Investment and Securities Act. Now, this is the problem. This technical committee sat as far back as 2016, 2017. CAMA was not signed into law until August of 2020. I'm addressing my question to the senator. And unfortunately, the ISA was not signed at all. Now, the problem with the ISA is that we that even sat on that committee don't even know the status of the ISA, because as late as October last year, the National Economic Summit Group invited a few of us to once again review the ISA again. Now, my question is this: how can the Senate, with its powers of legislation, assist us to make laws in good time? Not just good time, quality laws in the most efficient manner. Because we have been involved in a lot of conversation here, moving, you are responsible, you haven't done this, you haven't done that. So in the course of our conversation, my focus fell on you, sir. So please, how will the legislature assist us? Thank you very much.
Thank you very much. So, number 3. Number 3. Yes, sir.
Thank you very much. My name is Yemi Oke. My reaction, briefly, is to my brother, distinguished Senator Ajibola Bashir. Of course, for obvious reasons. He picked on us vis-a-vis curriculum and pedagogy. And I beg to disagree with him, because, of course, I can only speak for University of Lagos that I'm conversant with. In terms of course offering, we have interesting courses that speak to contemporary realities. And you agree with me that even your PhD that focus on securitization, why issues we picked?
Please, remember you have 1 minute, Yemi.
Thank you very much. So, coming back to the issue, you're tasking us to do so much, but nobody seems to be talking about our welfare, the condition of service then and now. And you expect us to build something on nothing. How will you help those of us who are impacting knowledge at that critical level to do better? and much more dedicated in our job. Thank you. I'm taking on that for FASU anyway.
Thank you. Thank you, Prof. Number 4. Come to the students now.
Yes, ma'am. So, good afternoon, everyone. I'm Oyebade Timileyin, a 200 level student of the faculty. So, my question is that I have a conclusion, actually, but to give that conclusion, I want to ask this question. That is there any council that checks the decisions of the courts before they become, like, applicable in other cases? So, if there is no council, so how do we check if those judgments are not, like, bad judgments and will evidently, like, mean bad laws, like applying to other cases? Then number 2, concerning the feature of law that states that law is dynamic, like it changes from time to time to suit the present change and whatever. So how do we check those old cases, like how do we check those old decisions to take them out, like not to be in use in new cases anymore? Like, is there any council that sits, like, to take out old cases that will never be in use anymore and to check decision of the courts before they can be applicable in other cases? That's my question.
Thank you. Number 5. The last one, the lady.
Good afternoon. Standing on existing protocols, my name is Awesu Aminat.
Can you speak up, please?
Hello. Standing on existing protocols, my name is... My name is Awesu Aminat, is a year 2 student of the Faculty of Law, and I'm asking this question based on what Professor Bambushi said. I'm asking why our classes are not based more on interactive sessions and research, and why we are made sometimes to cite exactly the same cases that our lecturers have cited.
Prof, can you hear her?
When we can be
Please, can you speak up so that Professor Bamboshe can hear you? She will take the answer. She will answer you. Can you speak up, please?
Why our classes are not more interactive and more...
Why our classes not more interactive?
And why we are not made to research recent cases, because I feel it is not only the jobs of the lecturers. Students should also be made to research on recent cases also. And as Professor Agomo said also, this should be like an interactive sessions between lecturers, not just going to class, sitting down with pen and biros and writing down exactly what the lecturers are saying.
Thank you very much. Okay, so 1 minute each. You have the first 3 questions. You have 3 questions.
I have 1. But before I go to the question, because they cut the time I was thrown off, I have to let Professor Peter know that I was admitted into this university in 1978. That's when I came to this university as an undergrad. But I was in the Faculty of Business. And I went for a weekend with my friend in Ife, and I sat in a law class. And I discovered that, wow, I'm missing. And you know, in those days, you can apply to a couple of universities. So I just stayed in Ife to pursue law. And when I finished, you know, the rest is history. I came back again in 1983, and then it's been very wonderful working with people. And of course, my great mentor, Professor Abiola Ojo, in the class, through hiking a ride and talking to Professor Ajomo, convinced me to leave the Federal State Council job I was doing to become a lecturer, and no regrets. Like Professor Omotola would say, you are blessed when you have the privilege of being a lecturer who can not only lecture, can practice, can consult, can advise, can advocate, can radicalize, can change life, can do so many things. So now to Abiola's question. There's always opportunity for using law reform, but it has to be deliberate. For instance, you know that the National Assembly, they have the National Institute for Legislative Studies and Democratic Studies. It used to be Legislative Studies alone before they added Democratic. And they have funds by UNEP, because I've participated in it, where they put down money to determine value that is coming out of them. And I remember during that time, they were forced to take in so many laws. And I think your ISA bill can benefit if you walk through the Nigerian Institute of Legislative and Democratic Study. Because the truth of the matter is that we don't recognize the fact that the practice of lawmaking requires some lobbying. When we're doing the Civil Aviation Act, I went to Ministry of Aviation to the National Assembly, only to be told by the new chairman of the committee, the lawyer, our brief has not been perfected, you have to come back. And this was the time when planes were falling down. So I looked at the Civil Ministry of Aviation people, they said, "Oga, don't worry, we'll take care of it." So I had to come back to Lagos. They had to settle their bill, set to perfect their briefs before the thing can be done. So the truth of the matter, if you think the National Assembly is going to pick up a private member bill for you practitioners to make money, unless you get it to be a government or a sponsored bill, it's going to be difficult. That's the truth and the reality of the system we have now. Not many of them are interested in lawmaking. In fact, I was a consultant to the National Assembly when they told me that I was not voted for. What this lawyer, professorial thing you are telling is too much. It's much more than the money we paid you. Just tell us, this is what you want to do, this is what you want. We don't want to do anything else. So it is also a challenge to each one of us. When you see somebody that is campaigning to be your legislator, find out whether he's a fit and proper person you want to put in that exalted. Thank you very much.
I think I will take it on Pro first. I will speak as a Nigerian citizen, not as the spokesperson of National Assembly, so I won't be defensive. Just as has been said, with respect, the quality of representation matter as to the quality of legislation that you put in place. Unfortunately, because it's democracy, and that's one of the problems of democratic governance that you have. If it is based on the basis of votes, a professor as erudite as Professor Shikwiton has the same votes as somebody who does not even know what he's doing. So one of the challenges of democracy is actually having quality representation. And I will say that the National Assembly we have today is perhaps the most underdeveloped of the three arms of government that we have here. You will recall that in 1966, after the coup, there was an interregnum until 1979. Then 1983, when Buhari and his gang also struck, there was no National Assembly. They are junta, we call them junta, and I don't have any, although I'm a member of the ruling party, but I was a pro-democracy activist, and we fought for the democracy. So they are junta. So the first thing they did was to sack the National Assembly, and until 1999, there was no National Assembly. And all of us know that at the of people get elected even to leadership position at the National Assembly, you have situations whereby you have 4 or 5 presiding officers over a period of 4 years. So the National Assembly, as at today, is challenged in terms of having necessary resources in terms of representation to be able to deliver on the demands of Section 4 of our Constitution. Then on the ISA that has been mentioned, I'm not aware that the ISA has come before the Committee of the Whole. And I need to briefly what's the procedure for lawmaking. If you have a private member bill, it will have to go first reading, second reading, then the principle of the bill will be tested, then sent for the Committee of the Whole House. So if those processes have not been done, I can exchange my contact with you. I'm interested in securities law. And just as my friend, who is also intending to be a senator, Professor Yemi Oke, has said, I wrote my PhD, and I must openly thank the Dr. Fidelis Odita. I used his book copiously. I wrote on asset securitization, and one of the building blocks of my work was reform of secure transaction law, in Nigeria. We say that you need to understand the processes and procedure. And there are a lot of pressures on the National Assembly as to which law you want to prioritize. Some of our colleagues are more interested in about setting up schools in their domain or over centralization of government. You can see people bringing bill as to enumeration of livestock when we don't have reliable census in Nigeria. So therefore, I think there's a need for us to interface and ensure that we have it done, and I volunteer to do my best to assist with the committee to be able to do so. Then on the issue of curriculum, and I say this, when you are doing masters or PhD, it's a different thing entirely. And I want it to, as a child, to look at our curriculum for lawyers and law students, so that when they come, I remember when I started law practice at Alumni, the very first day that I entered the place, we were to do NGA transaction and we want to do a forward sale agreement transaction. And then the question is, how do you ensure risk of insolvency, risk of diversion, and so on and so forth? So I will say that our curriculum need to be examined, notwithstanding. Then on the issue of law reform, I will say that all law reform effort is under-resourced in Nigeria. The budget of the Law Reform Commission is mere pittance, and also the quality of people. We should not see such offices as political offices. We should put erudite scholars that will be able to interface with the law and come up with quality research that will definitely assist us. I know the kind of work that was done by the duo of Professor Shipiton and Professor Shibadio on electronic generated evidence that led to Section 84. And of course, we still have challenges in that regard. Then on the issue of what do we do to ensure that we have quality law, I think it has been answered by the learned Attorney General for your state. Let us, as scholars, intellectuals, and patriots, take more than passing interest in who represent us. If you say politics is dirty and you don't get involved, then you get ruled and your affairs being run by people who are dirty and who are terrible. Thank you very much.
Thank you very much.
As a way of doing a concrete something, before I pass the mic to Prof, if you are interested in running for office in the future, please stand up. Prof, please pray for them.
Okay, thank you. It is good to aspire to hold offices, whatever it is. My prayer for you is that you will be guided, that the Lord will grant you wisdom, you will be sensitive, and your reason for going to serve is that you want to give. We are not going to share the national cake. We are going to bake. We are bakers. For the bakers, those who are going to sow the seed, not those who are going to cut their own national cake. May the Lord be with you. In Jesus' name. Now, question 4. That question 4 is going to be taken by Honorable Justice Ekpaye and our lead speaker, Professor Fidelis Odita.
This has truly been a fantastic homecoming. Not only have we listened to a beautiful paper, beautifully presented, we have also had some spiritual dimensions to it. I wish I was on the other side. I would have been prayed for by Prof as well. Before I go to that question 4, I believe I heard a question that talked about whether it's not right for us to have legislation to reverse judgments that may be par incuriam or whatnot. I think I had somebody make that kind of suggestion or ask that question. And I just want to maybe just run some caution here, because we all remember the history of this country when we were under the military interregnums. A decision will come out from the Supreme Court or whichever court. The Armed Forces Ruling Council is displeased with it. The next thing you know is, if it is not decree number 1, it's decree number 2, and so on. And we know the kind of injustice that that has done, not only to our nascent democracy and the rule of law. So I would be very, very careful about saying, oh, we should bring forward legislations to correct bad decisions. Look, bad decisions, no matter how, they had a way of going their own way. Eventually, everybody abandons it. And I'm sure Prof, a researcher here, can give us a number of bad decisions that nobody cites anymore and nobody relies on it anymore. Because you see, the judiciary itself is a self-correcting system. It may take a little while, and people may be anxious that, look, it's too slow, but the change will come. And I would also like to add that, as in all human endeavors, human beings make mistakes. They make errors. And so that is why law itself has introduced this pyramidal structure, this vertical structure of the court system. So even when the lower court makes the mistake, there's an opportunity to correct it at the Court of Appeal. And if it needs be, it just goes right up to the apex court, and somebody must definitely get it right. The Yoruba say that everybody cannot sleep and everybody is facing the same place. Somebody would wake up and know that, no, something has gone wrong here. Let us correct it and let us do that which is right. I think question number 4, if I am correct, was about whether there was a body or a council that can sift the old cases, anachronistic cases, and, get it out of the way. Again, the system does not perpetuate itself. Usually what happens is that the latter decisions begin to get more prominence. And of course, if there is a solid older case where the principle is firm and it is solid, it will still get used. But then over time, and that is why law changes, even as the society changes. I mean, the way we were doing things 20 years ago, 30 years ago, things have differed. Gender rights, for example, the right of women to now inherit property, these are judge-made laws, and they just come in and in recognition of the aspirations of the people. So that would be my own contribution. And I think stare decisis, we should still continue to abide by the theory. Thank you very much.
I think Honorable Justice Ikpaye has answered the question, but just to add to that, in systems where case law has become anachronistic, you could get the Law Reform Commission to look at them. But in Nigeria, where you politicize everything and you see the Law Reform Commission as an opportunity to chop, you put people there who have no idea what they are there for, who have no agenda to reform anything, and so the system remains the way it is. But apart from the Law Reform Commission, you could also get the judges themselves to review some of the cases, and you see that in many countries where the law evolved. And I think during my presentation I mentioned, for example, in relation to illegality, how the law of England has changed in the last 5 years. So laws can change. That doesn't mean that stare decisis is not useful. It means that because it's judgment law, and because societies evolve and social, political, and economic conditions change, sometimes it is necessary to adapt the law to those changes. Thank you.
Thank you very much. Prof, why is the classroom not interactive or more interactive?
Thank you very much. I so much love that question. And I will say that any faculty of law in Nigeria, in this 21st or in the 22nd century, that is still teaching the traditional way by writing of notes or dictating of notes is archaic and should be shut down. There's what we call clinical legal education, and this is student-centered class where the lecturer is just part of the class. It is a student-centered class run under Unilag, and this started since 2007. This is where students are the ones that center the class. You give students, like in criminal law, you come and give a student or a group of students the case of R and Nwoko, and you tell them that it is a case on it is a case on the defense of provocation, that they should come to class and to come and act. And you see these students, and that is why students are not performing well in some of our institutions. And when they go to law school, they do not perform well because now we are just feeding them with cases. Students should be able to come to class and they should be able to read. They should come to class. They should be able to come and tell us what is happening. Now, these are practical classes. Now, any faculty of law that does not have a clinic where the students can put into practice what they are doing is not a faculty of law in the 22nd century. How on earth can you teach, visit to the local Cinco, and you are teaching it in class, reading notes? I remember that since 2007, I've never taught visit to the local Cinco in the class. It is taught on the field because I have to take the student out of the class, demonstrate to them how the visit to the local Cinco starts from the court by telling them that, okay, now demonstrate something in a graveyard. One of the students is saying that you cut it to this side, you cut it to that side, but the judge does not understand. So what does the court need to do? The court will now say, the application is brought, let's go to the local Cinco. So you take the class, however the class is, and you take the class just near your class to go and do the visit to the local Cinco. How can you teach hearsay evidence just reading your notes without practicals? And this is why I agree with the student that has said, in a 21st century faculty of law, you cannot afford to be teaching the traditional way. And I'm saying, you cannot do away with old cases. But any lecturer that is still using all the 1840-something cases just to teach without citing recent cases, we talk about precedents, but there are laws that has come. Now, Professor Yewo has just given us a case of Ode 2021, but it is based on an old principle. And the lecturer should be able to tell you what the old principle was. There is all the cases of Stevenson, those people that saw Stevenson, but there are present cases with it. So I agree with you that cases must be updated. We cannot continue to use our old notes teaching students. It is unacceptable. And I say unacceptable. Recent cases must be given. Precedents will be given on old cases. And students, this puts you on your feet. You will have to read. And you will come to class to come and say, what happens to this particular case? And what does clinical legal education do? It puts lecturers on their feet because students are reading. It's a student-oriented class. They come to class, they have read, and they come and challenge you. So what it does, it's good for every faculty of law to take up clinical legal education. Don't use the old pedagogy, use the recent pedagogy, which is clinical legal education. Thank you.
Thank you, Prof. Thank you. Thank you. We have come to the end of this session. It's been a long session, but you can agree with me that it has been well worth it. Thank you for the participation. And thank you, the panelists. Thank you, our lead speaker. It has been a very, very, very rewarding experience. Thank you.
Thank you very much, Professor
Thank you. Please, one more time, can you put your hands together for them, please? Because of our time, we'll just jet into the next session quickly. The next session, Unilag Law and the Culture of Excellence, bringing out the best in you. The moderator will be Ms. Stella Duru, partner in the law firm of Banwo and Ighodalo. Can you put your hands together, please? Because of time, she will be on stage to actually do proper introduction, but I need to bring the paneler up on board now. I'd like to invite Mr. Shola Adekpetu. Please put your hands together for Mr. Shola Adekpetu. Please kindly come up. Mr. Dakbo Olanipeko, S-A-N, please kindly come up. Mrs. Funke Buckner, please, would like you to be on stage. Mr. Uche Ihediwa, S-A-N, the Attorney General of Abia State, please come on stage. Can we put our hands together for them as we call them, please? Prince Yemisi Shilling, please kindly come up. Miss Ayodele Kadiri, please kindly join as well. Can we put our hands together for them, please?
Well, we have a task, and our task basically is to speak to the culture of excellence. So on the stage with me are persons who, because of time, we can go into their very detailed bios. But I will tell you very easily that we have very powerful powerhouses sitting here. We're talking about persons who have, over the years, set up their own law firms, and the law firms have merged with international law firms and are really doing great things in our country. Sitting to my immediate left is one of the biggest art collectors in the world, who has a first-class, world-class museum in Nigeria. We also have, sitting on the stage, the Deputy Chief of Staff to the President. We also have, before until recently, the youngest person to get conferred with the Silk, Senior Advocate of Nigeria. We also have a pretty young lawyer, we would say, who is doing great things in the tech space. We have an Attorney General of Abia State sitting here, and we also have someone who is the founder and the owner and the person that basically does the biggest events in Nigeria. And one thing we all have in common here is the fact that we're all alumnus from the great Faculty of Law, University of Lagos. My name is Stella Duru. I'm a partner of the law firm Banwo and Ighodalo, and it's my task today to moderate this session. And one thing I'm going to use to set the stage is to just speak to this culture of excellence that we have been benefactors of, but basically have helped us in building the careers that you see. If you know anything about my firm, a firm that has just been ranked as the best Nigerian law firm, I'm sorry, I had to say that. But of the 15 partners that we have, 10 of us went to the Faculty of Law, University of Lagos. What else do you need to speak to the fact that really and truly, like the distinguished Professor Shipito said, we are first. We really and truly do not have any equals. And you're going to hear from all of the people here about how, going through the faculty, it has helped them in building themselves and building the institutions that they've worked with, they founded, and they continue to, provide support to. So I'm going to just basically start with the gentleman, the Prince, sitting to my immediate left, who I said is the largest collector of art. Now you think law, art, culture. How do you make that, bridge? How do you move from reading the law to being a curator of fine art. But that's not the question I'm going to ask him now. I'm going to ask each person to speak to the values that they learned whilst they were in the faculty that actually got them ready for the careers that they found themselves in. So, sir, if you could please start.
Well, I came to University of Lagos to read law. I've had already obtained some professional degrees in University of Ibadan and University of Ife. And, but something stood out with University of Lagos. First of all, in terms of the university, the issue of reading African jazz was very important because it opened my eyes to the importance of our indigenous culture and made me realize that there is a lot about our indigenous culture that we have taken for granted. I could see my parents, alluding at times to some proverbs and so on, but University of Lagos allowed me to understand and appreciate our culture. Now, when we go to Faculty of Law, there was a great teacher that taught me, Olaide Adigun. He taught us the law of thought. And I don't know whether the students are still using that book now, in which, in that his book, a lot of maxims in equity were discussed in his book, and they were taught using Yoruba proverbs. That made a lot of difference in me and made me want to explore more about our indigenous culture. Before then, I had been collecting, art in a small way, but it made me explore. Now, what values have I discovered in our indigenous culture? First of all, as against what is happening in today's society, our indigenous culture teaches humility. Humility, honesty, integrity. We, for instance, the Yoruba culture talks about omoluabi. It talks about bravery, love, contentment, hard work. Those are the things that our indigenous culture has taught me, that I must say that Unilag exposing me to our indigenous culture has helped me greatly in my boardroom experience, because I have an extensive boardroom experience both at the corporate level and the statutory level, and it has guided me in ensuring that those values, which are very core to our culture, our indigenous culture, have governed my relationship, my relationship with in the board and with top management of the various organizations I have been able to serve. Not only that, in terms of our culture has made me realize that you don't live for yourself, you live for others. And that what is most prime in life is for you to give instead of hoping to receive. According to the School of Positive Psychology, Martin Seligman, who has espoused this, it's also part of our culture, our indigenous culture. You give. Our forefathers gave their lives for our society. Our forefathers showed valor, courage, and so on and so forth. Those are the kind of things I have been able to take away from University of Lagos, which have greatly shaped my life, that have made me. I donated that sculpture in front of Faculty of Law, which tries to align and spotlight the interrelationship between our indigenous culture and justice. Also, I established a professional chair at the University of Port Harcourt, where I have a chair occupant that goes around the world selling the values in our culture, our cultural values and our the various things that hold us together as a nation. I've also done same at the University of Ibadan, where I donated a major monument, apart from the fact that I've established Sub-Saharan Africa's most valued museum of art, that is celebrated all over the world. Thank you.
Thank you so much, Prince Shilon. If the learned SAN, Dapo Olanipekun, could just speak to the values that he got as an undergraduate here and how that has shaped his career. Thank you.
All right, thank you very much. I think I would just capture mine in one word, which is excellence. One thing that I learned and that my very young, still young, at the time observed very keenly was excellence. Excellence is a very nebulous term. So when we talk about excellence and the word is bandied around, most people don't really know what we're talking about. Excellence is simply doing what you do very well and then being the best at what you do. At the time that I studied law at the Faculty of Law, it was under the regime. And most universities, the best system in Nigeria was strikes. At the time, the school was being led by a distinguished professor from the Faculty of Law, now of blessed memory. And one of the things I observed was how, there was a nation, and I saw a system where things actually worked. And so from that very early day, I learned that when you're talking about change, you start to make the difference at the micro level. That was the first thing I learned. The second thing also was the best minds that I was privileged to learn under. I mean, from the likes of Mr. Adekpaye to my left here, Professor Shikpiton, SN, Professor Akonki, Professor Bilade, Adeogun, I just saw a collection of best minds. I saw that university would not compromise excellence. And those are the values that I would say I've applied in my own life and my career. Thank you.
Thank you, Dapo. Thank you very much. I'm sure most people are expecting me to go straight to Mr. Adekpaye, but he was a lecturer during my time here, and he taught us most of those values. So I'm not going to go to him to speak to values that he got here as an undergraduate. I will segue back to him after I've spoken to my other panelists. So moving to the panelists on my right, I would ask Mrs. Funke Bucknell-Bruthe, who happened to be in my class, the class of 99, when we were in Unilag, and who has the biggest event planning company that I know of that is doing great things in the event space. So if you could just speak to the values that you learned whilst you were here, even though you didn't really read the law or practice the law, I guess most of our people here will want to know. Thank you.
Thank you very much. Thank you. Putting me there and saying that I'm not practicing. I'm practicing kind of. What do you guys think? So I think for me, what I learned, just being here studying law, I learned the value of hard work. I learned how to never give up. A lot of times people talk about not giving up. I was in Unilag studying law, a course that I probably didn't really enjoy like everybody else on this panel. I wasn't very excited about studying law, but one thing I learned was determination, to see it through to the end. And seeing it through to the end because I didn't want to fail. I wanted to prove to my parents or prove to the world that I could finish. So I finished the law, but in the process, I learned a lot. I learned hard work. I learned about never giving up. I learned determination. I remember when I also, I didn't do so well in land law. How many people are doing land law at the moment? Have you got into land law? Do you enjoy it? Oh, fantastic. I didn't enjoy land law. I failed land law and had to take it again. But when I took it again, I passed so well. So for me, I learned that I could do anything that I put my mind to, and that's how I was able to pass. And of course, I came out with a very good degree as far as I'm concerned, Yes. But I learned the value of, those are the values I learned. And I also learned as well, the value of relationships, networking, community, the value of people, it has helped me even in my business today, because everyone around me, when they were even in my class, even people that were my juniors or were seniors, people wanted to also teach and learn and give and share. And I learned that because, you know, we don't get a lot of that in the society at the moment. So just having people that wanted to see the best in you, those are the things that I learned just being in this faculty of law. Thank you.
Thank you, Funke. I'm now going to move to Ayodele Kadiri. You're the youngest on the stage, and clearly you're the one that would be said to be the person that understands this generation more than anybody else on this stage. And what we hear a lot during these times is that value erosion is very high. There are no real values anymore. So we've left the faculty for a bit. So maybe you have more recent, memories of being in this faculty. What values would you say? Are the values that have already been mentioned by the other panelists, do they still exist today? And do you think there are things that will still continue to exist as the undergraduates are looking to build their own careers after they've left the faculty?
Okay, thank you. Good afternoon, everyone. So yes, the values still exist. In fact, by the time Madam Funke was talking, I was like, she already said everything I wanted to say. But what I really want to say, and it was because I was preparing for the questions on the panel, I was able to think about it. And if you asked me and talked about values, what I would say is that the Faculty of Law gave me the law library. And I'm going to explain. So that time, back then, when you finish from, because I came in through post-UME, so after a year, when you're traipsing around the campus, going from GST to sciences and everything. So my GP was really great. I was like on a 4.8 or something. And so after I spent when I came to 200 level and I spent my first year at the faculty, I didn't have a single A. I think I had B's and C's. And so my GP dropped seriously. And then I knew that I had to, I didn't even know, right? Okay, I was serious. I felt like I was doing what I needed to do. But in that time, and from my first year to my final year, because I wanted to finish with a first class, it was a battle of I want to finish with a first class. So every year, it was that focus for me. Because I did some extracurricular activities while I was here. I participated in Enactors, I participated in, I was also the editor of the Lex Observer. So I did a lot of things. But what I also did was that every point in time, I made sure that I set out time to study. And that taught me focus. No matter what was going on in my life, I had to set out time to pay attention in class, to make notes, to go to the library and study. And when I mean study, I don't mean maybe just read Cordinley and Aluko, like read Clarks and Lindsay, like read Streets, like the way Dr. Chiuba taught us thoughts. That's what she was saying about the lecturers and the relationships, how they make you go into details. If Dr. Chiuba didn't teach me thoughts, I don't think I would have learned about like House of Lords, all those things. She will make you read English judgments. She will ask you questions. She will tell you, why do you think this case happened? Why do you think the English law departed, the House of Lords departed from this decision? And I'm like, I just want to study Nigerian law, please. But that was the kind of training that we got. And so it was the law library for me, that focus. And like I said, it was a constant battle for me. I wanted to finish the first class. So year 3 came, and I don't know whether it was criminal law or whatever that dealt with me. Year 4 came, landlord equity dealt with me. But year in, year out, I had a space in the library. My particular seat, everybody just knew. And it was just learning to deal with rejection and failure, because in life, you get like a lot of no's, a lot of sorry, application is not needed now, a lot of we don't need you for this job right now. But I guess when I look back, I think all those experiences just taught me how to still stick true to the game, taught me to deal with rejection and failure, taught me the value of having people around me that knew better, and I should also look ahead to them. So all of these things, like I said, if I look at the law library, it's just really rich. All those experiences really made it. And I think that the values are still there if you apply yourself and if you make use of the opportunities that are available to you right now. Thank you.
Thank you so much, Ayodele. So we've heard some of our panelists speak to the values, and the values yesterday are the values that you'll still see that will still continue to push you to be excellent. We're talking about values that speak to being humble, humility, omolo Robust. Integrity, hard work, relationships. You really and truly can't do it alone. Tenacity, the ability to stay the long haul, to be there regardless of the challenges that you face. So some of these things are the values that the faculty actually made most of us learn and live by, and that has, helped us in shaping our careers. Now, Mr. Shola Adekweton, who is one of the partners of a law firm that is now known as Denton's Acres Law. And my question to him is, we've heard about the values, we've heard about how fantastic the faculty is. Most people leave and they want to work with law firms that are already established. What made you set up your own, and what has actually kept that law firm to be the excellent law firm that we know it to be, such that it was now then that beautiful bride that an international law firm wanted to get into partnership with? Could you please just tell us a bit about your excellent journey? Thank you.
Thank you very much. Good afternoon, ladies and gentlemen. I think that we set up the firm in 1991, myself and my partner, Afolabi Caxton Martins. Before that time, I worked with a commercial law firm in Lagos, Colloquium Co. And I know that when we started, it wasn't because either one of us knew each other from before and said we're going to set up a law firm, but we met just because both of us at the time would have appeared to have been stranded. So I was working with Colloquium. Colloquium had to leave town. He went to England and he took a long sabbatical to England and left the law firm with all of us there. So I found myself without a principal, as it were. Afolabi Caxton Martins, at the same time, too, had left the law firm he was working for, and he was looking to, set up a law firm. So we met, we were introduced, and we then decided that we would do this together. Now, what was pushing us at the time, we felt we had something different. We were hungry, and we felt that things could be done differently from the way law firms, law practices were being operated. So we set up that firm, and then in 1991, in 1993, Mrs. Funke Agbo, Senior Advocate of Nigeria, joined us as a partner. And in the year 2000, Mrs. Kemi Shegun joined us as a partner of the firm. So the four of us were partners by the year 2000. And then we worked very hard. Now, I will say something, and this is just to let you know what pushed us so hard. We didn't have any money. Like I said, we both found ourselves out of work. So we had to borrow money to start the firm. 100% equity from loan sharks, exorbitant interest rates. And we had to pay salaries every month. Now that was the impetus that pushed us so hard. We were so focused on creating new work. We were focused on ensuring that the firm survived. We were survivalists. Every month we had to congratulate ourselves for getting through that next month. And that just propelled, that's propulsion, as it were, that started from the beginning. The energy of having to survive, that survival mode that we always were on, is what pushed everybody that came through the firm at the time. If you want to call it hustling, we were hustlers. But that is what got us to where we are today. We never stopped running from that very first day till now. So when it was time for, we built up the firm, we now have relatively, decent size in terms of numbers. And because of the values that we inculcated right from the beginning, integrity, creativity, and excellence, I think that's what put us out there, and that's why Denton's, when Denton calling, we were one of their first choices. Thank you.
Thank you so much, Mr. Adekweton. Now I'm going to go to Mr. Adekpaye, you've transitioned from student to lecturer, and now you work with the president. Whilst we know what most people will say about people in government, we know that with the values that you have taught here and the ones you learned, you are certainly doing something different as you work with the presidency. Could you speak a bit about what your success is? What are the things that have driven your success in government?
Hello. Okay, thank you very much, Stella, and fellow panelists, dear lecturers, professors, and other staff of the faculty, and our dear students. A great pleasure to be here. I think first to this hall in 1981, you know, doing like an induction for new students. But then I wasn't in the Faculty of Law, I was in the Faculty of Arts. I actually read history, B.A. Hans history, for 3 years. Went for youth service before I came back to the Faculty of Law. But in the meantime, I didn't just come back by accident. I was an observer of the faculty from the outside for those 3 years. The lecturers, the courses, the books. I actually had occasion when we are in class or in the library reading, copy the law books to see what they were about. And I was so keenly interested, I knew that I had to, at some point, return to it. But we don't have much time for all the story, but I said that to let you know that I had a perspective different from that of the typical student who came straight to the Faculty of Law. What is even more interesting was that after law school, had a bit of work in private practice, and I then came back for master's at the Faculty of Law here, following which I remained as a lecturer. So you can see that I was here as an undergraduate student, as a postgraduate student, and subsequently as a lecturer. And I was asked to speak specifically to my role as a public servant. Again, I have to let you know by way of background information that I left the faculty. I was then a senior lecturer and sub-dean of law in 2001. On leave of absence, the assumption was that I would be out for 4 years at most. Even 2 years, I was thinking then, because 2001 was midterm for the government of Lagos State, and I was special assistant legal matters, working to the governor, but working with the then Attorney General, Professor Yemi Osinbajo, who is now the Vice President of the Federal Republic of Nigeria. So I thought I would just spend those 2 years, but I ended up, after the 2 years, being offered the position of a senior special assistant, after which I was offered a cabinet-level position as special advisor on taxation and revenue, after which I was offered the position of Attorney General and Commissioner for Justice, Lagos State, after which I was offered the position of, the current position of Deputy Chief of Staff to the President, which makes me the Chief of Staff to the Vice. Now, in public service, because I always had a tenure, I wasn't there from 2001 to date. waiting for the day I retire. I was always there for 2 years or 4 years at a time, and then it was as if I waited every 4 years. So to have remained that long and made successive progress meant that my experience at the Faculty of Law here. Okay, so I'm thinking then that at least I must be doing something right. If we don't have the time to go into details of what exactly I have done in public service, but it's a matter of public knowledge, both in the taxation or public revenue field, or as Attorney General, or as an administrator. So what was it then that we found in this faculty that was different? Because I was in another faculty, mind you, before I came to the Faculty of Law. I found that Faculty of Law, University of Lagos was uniquely placed. It attracted the best lawyers, best professors in Nigeria, and it continues to do so. So, in my time, we had professors, we had Professor Adeogun, you must have heard of him, of blessed memory, Professor Ajomo, Professor Ojo, Professor Adeyemi, Professor Viegara, Professor Obilade, Professor Motola, Professor Akonki. Now, to have all of these in one faculty was a real big deal, because there were faculties that could hardly boast of one professor. And these professors were supported by brilliant young men at the time, but, well, I suppose still young now. The Vice President, Professor Shibajo, was one of the young lecturers supporting these greats at the time. Professor Taiwo Shikwiton, too, was here at the time. Professor Fogam, I've seen today, Professor Agomo, who modulated the earlier session, Professor Mowo, Professor Yewo, who was in the last panel, Professor Anifalaje, Uzodike, Utuama. So we had this crop of academics who were the most respected in their field at the time and even now. And what did that do to us? It gave us the belief that we were having the best. We were ready to compete with anyone who read law from anywhere in the world. And the records, and they continue to show that, the records showed that our products will go everywhere and excel. At a time when I was here, even Harvard Law School annually would send me application form to give to my students, because they had 1 or 2 students from here who excelled. So they didn't wait for our students to apply, they would send application forms. And within the faculty itself, you know, we were in the University of Lagos, and that also mattered. Because I remember one of my most memorable courses outside of law was psychology. I think it was Professor Moluabi that taught us then. Until today, I mean, that is my pet subject outside of law. If I want to read anything else, you are likely to find me reading something related to psychology. So what I'm saying is that we also had these connections. Even as a teacher, I was teaching Faculty of Business, Faculty of Environmental Sciences, and so on. So we had these cross-professional relationships, which enriched us. My friend here spoke about the general course, just that we did, in our formative years here, where general African studies, where you are introduced to all sorts of things. So the great lecturers were not only in the Faculty of Law, they were around us, and that had an effect. Then the way we presented ourselves, and be sure that you are going to have to answer for that throughout your career, the way you even present yourself. So if you are in the presence of these grades that I've mentioned, and you are in a faculty where everybody was really in awe of the subject, everybody was interested, it really demanded hard work of everyone. There was no time to just lay about. At the time I read law, it was almighty June. And you fail anything at all, you have to come and recite. You fail it, you repeat. There was nothing like carryover. So the discipline was great. To run through it in 3 years without any incidents and have a good result, you know that you are ready for the world. You know, so I think all of these things put together, and we were inspired because our lecturers were appointed by the United Nations, by the World Court, we could see them function, International Labour Organization, we could see them function internationally. Then locally, we had lecturers that were appointed to the Law Reform Commission, to be commissioners, to be ministers. We could see them functioning at every level that a student could possibly aspire to. And that did something for us. It instilled in us the confidence that we could also do it. We knew how we had to also present ourselves, you know, in wherever, whatever we find ourselves in. So without taking too much of your time, all of these things taken together, I think definitely molded my approach to work, my relationships, professional or personal, and so on and so forth. So there is you cannot underrate or underestimate the value that you get from being in the right company or in the right institution, being exposed to the right people. And that, I think, is definitely what I took out of here. So I take Unilag, anything Faculty of Law, I take it seriously, because what I am today came from that. Thank you very much, Stella.
Thank you so much, Mr. Ipae. If you were listening intently, the right institution, the right people, the right values, these are the things that would help you build a culture of excellence. And that will follow you everywhere you go. Now, going very quickly to Leonard SAN, Mr. Uche Ihediwa, sorry about that, who is the Attorney General and Commissioner of Justice of Abia State. We've just heard Mr. Ipae, who is a public servant. You are also a public servant. We have heard a lot of the panelists speak to values. We've heard about discipline. We've heard about things that you should ordinarily do. But we're seeing a lot of things, at least with some of us that are employers. There are certain skills that appear to be lacking with the younger generation. So from where you sit, what skills do you think would be the kind of skills that an excellent lawyer or professional should have, especially if you're one that has graduated from the Faculty of Law, University of Lagos?
Thank you very much. Good afternoon, or good evening, everybody.
Good evening.
I think I'll start by paying my respects and gratitude to those who taught us, who mentored us. I've seen one of them, I've seen some of them here, because the values they put in us, it's incomparable. I'll start with one. As a lawyer, you must be bold. As an Akokite, you must be bold. And Professor Yebode telling us things like When you live here, you should be able to sit eyeball to eyeball with any lawyer in the world and stand your ground. So that, and I want to thank the university, the faculty. These type of interactive sessions are very important for mentoring the younger generation of our Caucasians. Because when you see us, those who have excelled in what you are learning, I think you will be bolder. And so, if I'll speak to what she said, one of the things I expect a young lawyer, one of the skills I expect is to be bold. And so when in my very first tutorial class in constitutional law before the learned Professor Shipito, and both of us argued on section 1, subsection 2, Prof, I have not forgotten. No matter what he told me, I had my own views. I was not penalized or punished for having my view. I want to thank the Faculty of Law. And when in an LLM class, late Professor Omotola came in to lecture us. I think we were doing something on secured credit. And at some point, I told him, Prof, you were not prepared for this lecture. He looked at us and said, yes, that he was just coming from an inspection, that's law school inspection. And he said, Uche, prepare a paper on it and present. If that was on Soka, forget the LLM. Hello? I say, forget that is the end of your LLM. But no, not in Faculty of Law. And I recall presenting paper on law of the sea. I made a mistake. When Professor Yebode asked me, are you talking of R.R. Baxter of Harvard Law School? That I made a reference. But there was a typo error. Instead of R.R. Baxter, I wrote R.M. Baxter. And when he asked me, I said, maybe that's the one you know. The one I know is R.M. Baxter. That is the Akoka boldness. I later found out that it was a typo error. I went back to him and said, yes, you were right. It's actually R.R. And of course, he asked me to redo it. And so, when sometime in my practice, I had to visit London and meet a client, a very big multinational, that's have a meeting with the legal department. For the first time, you know, I will be expecting questions of law. But the boldness Akoka put in me, I was very bold going to that meeting. And so when they introduced themselves, this one said he graduated in Cambridge. This one, Oxford. The other one, Cambridge. I said, okay, no problem. So when the questions, the first one came, I answered, and they paint a scenario and asked me, what will the Nigerian courts do in a situation like this? I'll tell them it's the same thing the House of Law did in Arrow and Baxter. They asked the second one, I answered in similar fashion. The third one, I answered in similar fashion. The fourth question was, will Abacha hand over? Hello? You see, what have I been able to demonstrate? That I have come from a faculty of law where I was proper, better than those Cambridge and Oxford people. And I tell you another thing. When in law school, the lady seated next to me, I'm telling you this to encourage you, was boasting. Because there's this one they call solicitor's accounts. In my time in law school, 1987, you know, the law school didn't have a central auditorium. They had one, but students had to stay in, you know, video or watch television. So the teacher said there are vacancies, people should come and sit down. So there was one next to me, but this lady will not allow somebody sit down. And before I knew, you know what she told me? Said, these local graduates. I said, okay, don't worry. The exam, that's the law school exam, will say who is a local and foreign graduate. Fortunately, it came out Of course, I was in 2-1, she was in 2-2, and we met at Ikeja. Then we were youth corpers. Went to her and said, hey, come, Oxford. You see the results? So Coca taught me boldness. Expect every lawyer to be bold. Even when you're talking nonsense, be bold about it. Then in public service, you see, I was happy when somebody said, how many of us here will want to go into politics? And a lot of you stood up and were anointed by Professor Agomo. I pray that we do, because we can sit here, talk and talk and talk, pontificate. If there are no good Akokites in various places in government, we will continue to peregrinate in the dark. This society cannot be better if we don't have quality people in various aspects of governance. So that's why I can say to my governor, well, if there is anything called Emeritus Commissioner, I am one, because I've moved from Commissioner for Lands to Housing, Land and Survey, Land Survey and Urban Housing, Urban Development, and today Attorney General. And it is because I was there, it's a pity Professor Agomo has gone. When I was in Lands, she had an application to perfect her title that had been lying for over 3 years. When an Akokai drew my attention to it, she got her CFO in 3 weeks. Why? It's not because of her, but the system was such that we were ranked by the World Bank. Abia State was ranked 33 out of 36 in ease of doing business. Under my watch, we became number 5. So it is that boldness that makes me stand before my governor with the Chief of Army Staff. I have his phone number. He looks at, hello? Hi. He looks at an estate I built, other people's money, which is another initiative. He wants 2 flats here, 2 apartments. And my governor calls, I'll give him 2. Now, you know, election is coming. We need the army. Hello? Hi. Yeah, the army. Hello? Don't think that the policeman that is watching over polling booth is watching over the polling booth for the purposes of making sure that the election is properly done. No, the man is at somebody's behest. So, I told my governor, these houses you now want me, you can quote me, that was TAOG. I said, these houses you want me to give Ihejirika, Chief of Army Staff, has been paid for and built with people's money. Sir, I will not do it. He called me aside. He said, do I realize, that's how I got Ihejirika's number. If you're in doubt, you can come, I'll show you. He called me aside. He said, don't you know this is Chief of Army Staff? I said, I know. He got to a point, I said, Oga, can I give him your own? Hello? Can I give him your own? Yeah, no. I said, okay, let me engage him. And I engaged him and talked to him, and of course, he backed off. Akoka also inculcated in me principles. Principles of doing good to all men, irrespective of whose ox is God. Those principles. Recently, you must have read that in the appointment of judges, a lot of people say, yes, appointment of judges today, like Oyebode will say, who guess what, when, and how, is dependent on who you know in this country. It's no longer dependent on merit, which is unfortunate. If you read the Sun newspaper, in appointment of judges by the Judicial Service Commission in my state, it was corrupted, and I was a member. Judges, would-be judges, had paid money to be made judges.
We would like to acknowledge some of our students who have worked particularly hard over the years, and a prize to the students with the best GPA in 300 level, 400 level, and 500 level. I'm going to call the names of the 3 students who will be awarded this year, and ask that, please, when you hear your name, if you're in the room, please get up so that we can recognize and appreciate you for your hard work and dedication. On Monday, please go to the Dean's office to collect the prize that the committee has. For 300 level, Alo Folakemi Temitokbe. Is she here? Is the student here? Oh, over, please, can we give her a round of applause? .400 level, Ekeocha Amarachi Jennifer. Amarachi, is she here? Okay. Please go to the Dean's office on Monday morning. There's a prize from the committee for you. And the 500 level student with the highest GPA is Sunny Adeniyi Praise Eboluwa.
This is for Mr. Ade Ikwaye, in appreciation of your participation as a panelist at the Great Homecoming 2022 Colloquium, this 10th day of February 2022.
Thank you very much.
Thank you. May I call on Dr. Dakpo Olanipekun SCN? Oh, okay. Okay. Dr. Olanipekun, thank you very much for participating. This is an appreciation of your participation as a panelist at the Great Homecoming 2022 Colloquium, this 10th day of February 2022. Prof, are you taking the picture on that side? Stand on the other side. Okay. Thank you very much. May I invite Chief Uche Ihediwa, Senior Advocate of Nigeria, Attorney General, Abia State. Is he still here? He has gone? He has gone. Okay, this will be given to him. Thank you. Who's gone? Anything at the plug? May I call on Mrs. Funke Bokno Obruthe? What's the name of that company? Zephaniah? Of Zafire Events. If you haven't heard of Zafire Events, you have not started. So, in appreciation of your participation as a panelist at the Great Homecoming 2022 Colloquium, this 10th day of February 2022.
Thank you. Thank you, sir. Thank you, sir.
My namesake. My own partner, Mr. Shola Adekpetun said, okay, Prof says he will do it, okay.
I have refused to allow Mrs. Agbo to be a judge in her own cause. They are in the same chambers. So I think I should do that. would like to appreciate you. The students must have heard about your name and your firm making waves in the market, and they're happy to see you here. We know we cannot pay for your time. We've kept you here for so many hours. Well, this is what we can give you in appreciation of your participation as a panelist at the Great Homecoming Colloquium today. Thank you. Well, I understand he wants to add a footnote. Thank you.
Good afternoon, ladies and gentlemen. There was something I was going to say just before the interruption, and I think I should. When I was here, I got into the University of Lagos in 1978, and I left in 1981. When I was here, I had an incredibly hectic social life. Incredibly hectic. So I was as particular to make the best grades as I was to get into Row Club at the time. Is Row Club still in existence today? Who's the member of Row Club here? Nobody? No more Row Club. Okay, this was one of the social clubs at the time. So where am I going to? That while you're young, you have to make the best of it. But at the same time, you have to have a good balance between a social life, going to parties and enjoying yourself and making the best of your youth. It was through those social skills that I met the one person who was my biggest support, my wife, because I knew how to dance. That's why she agreed to go out with me. But I also read very hard. I played hard and I read hard. When I finished with the second class upper. And guess what? Those social relationships that we made, my very best friends today, were made in University of Lagos. And we're still friends till today. And we help each other all the way. Those relationships that I made during my social life in University of Lagos is what is propelling all of us, supporting each one another as we go along. Everybody here, you don't know who is going to be where tomorrow in future. So you could be sitting down next to the next governor of Central Bank. You don't know. So it is important that you make your relationships and keep them. It's not only about your academics. It's also about a network of contacts that you make. I wish you all the best and God bless you.
May I? Thank you, Mr. Adekwetu. That was Ojoro, but I had to do that. May I invite Prince Yemisi Shilon? Our participant who talked to us about arts and culture. We are very grateful that you're able to come. This is in appreciation of your participation as a panelist at the Great Homecoming 2022 Colloquium, this 10th day of February 2022.
Thank you.
While you are clapping, you'll be surprised that he's my elder brother, Egbon. But he was my student. I taught my elder brother. And I confirm that he was a well-behaved student. Now, if you don't know the history of the statutes in front of the faculty, the lady with a blindfolded holding, he donated that statute.
Well, I'm his elder brother because, I'm his elder brother for sure. He taught me because I had got my degree in engineering. I had got my master's degree in business administration with specialization in finance and marketing with distinction. I got second class upper in engineering. I came to the University of Lagos, I had second class upper. I went to the law school and had second class upper. I am also a fellow of the Chartered Institute of Stockbroking. I'm a fellow of the Institute of Auctioneers. I have many professions. Thank you.
Thank you, thank you.
Thank you, thank you, thank What about who's the last person? She's here. Okay. All right, may I invite May I invite Ms. Ayodele Kadiri, our youngest panelist. Is she still here? Thank you very much. She's receiving 2 plaques as one of our guest lecturers. She was teaching the students law tech and the innovations in technology in law. Ms. Ayodele Kadiri, in appreciation of your participation as a panelist at the Great Homecoming Colloquium, both as a panelist and as a guest lecturer. This is another one. Congratulations.
Thank you, man. Thank you for the opportunity. Thank you.
Thank you. Where is it? Can I have it? Because I can't see her name. May I ask Mrs. Osayojigo of Amnesty International, who participated as a guest lecturer. We are honored that you're able to come. We keep seeing you making pronouncements about some of the ills of our society. I hope that we are getting some traction. Thank you very much for joining us and sharing your experiences with our students. Mrs. Osayojigo. In participation as a guest in appreciation of your participation as a guest lecturer at the Great Homecoming 2022, this 8th day of February 2022. Thank you so much.
My pleasure.
Wonders will never cease. Somebody is in for a surprise. That he does not know that he has a prize. He's a member of the planning committee. Oh, he's a member of the Alumni Relations Committee. Also a member of one of those people who also lectured. And unknown to that person, a plaque has to be presented today. So please join me in thanking Mrs. Funke Agbo, SAA, for being ever so there, chairperson of the planning committee, and also a lecturer in maritime law. Funke, on behalf of all of us, excluding you, we present this plaque to you in appreciation of your efforts and your time and everything. The member of the committee, and please join. Surprise.
It's been a good time. Can we put our hands together for all the committee members? Multimedia, let's go, please.
Particularly, I was very fortunate to have the kind of lecturers that I had, because they were lecturers who followed up with my progress. We had lecturers then who would call you when they don't see you in class, would call you to find out from you whether or not you understood the things that you were learning. And they were very good lecturers who took us in the various courses of law while I was in university. I need to mention in particular Professor Adigun, who took us in equity in my part 2. He was particular about my progress, and I'll tell you why. It's an interesting story. Like I said earlier, I wasn't exactly the most studious of students, and I only became very particular about my work and how I was going to end up when I finished my part 2 exams. But my part 1 and all the way into part 2, I was just an ordinary student. I just wanted to leave university with maybe a 2-2, and I'd have been very happy even if I had gotten a 3rd class. That was the way I was until I got to part 2, when Professor Digun taught me in equity. Now, it so happened that we had a midterm test or mid-year test in equity. I didn't read for it because I was very much a socialite in the University of Lagos. And I remember the grade that I got in that equity test. I got 18%. And of course, I wasn't very happy about it, but hey, you know, it wasn't the main exam, so it didn't really matter that much. But by the time I started reading for my exams, I decided to put in my best into my work. And I studied equity particularly hard. Now, I remember Adigun coming to me during the equity exam. And he came and he said, Adegbetun. I said, yes, this is what everybody was quiet, everybody was, you know, working, doing his paper. Adegbetun. He said, I hope this is not 18% work in the whole class. I will never forget that. And I told him, no, sir, you will see this one, sir. It so happened that I got an A in equity at the end of the day. And then he called me and he just told me that you can see what you can do when you put in your effort. He congratulated me. But I've never forgotten that statement. I hope this is not 18% work. It's always there.
There has been some changes, or perhaps maybe modifications to how laws are now taught. And just as it applies to any other profession in the faculty here. So what we find these days now is that, one, there is now an infusion of what I would call the PowerPoint presentation, you know, into the teaching of law, whereby, I mean, you can share with students the high points of what you want them to, to know, and as a result, you relieve them of having to take notes in the classes, and then leave them with the materials that they would need. But that will also require that they go back to the library to study, because the PowerPoint presentation is actually a summary that, I mean, it's quite sketchy, but it highlights the key points that students need to know. The working there is that they are expected to return to the library, check up the cases, read the materials, the secondary sources, even go over the primary sources so that they can be sure, and from there they can make their notes appropriately. That is one level. Another level is that we are in another age now where in further infusion of ICT in learning, and of course in the COVID world era, in the COVID world, you now find that it is not all the time safe for society to have aggregation of students in the classroom. So we now have, means by which you can communicate with people in diverse locations. So the Zoom method is there, and there are so many other platforms through which you can communicate with people in diverse locations and in remote locations as well. So, and particularly last year, most of our lectures were held online. Even examinations were conducted online. Monitoring and supervision of examination were done online through proctoring. And then we were able to at least achieve what we wanted to achieve without really holding students back or holding them down until the COVID was over. This COVID may not go, as you know, so quickly.
You must have that at the back of your mind. And therefore, we make sure that our students know that when they leave this place, they will be not only representing the faculty, they will also be imbibing social values to the society at large.
I will say that the greatest the greatest challenge that we face is the challenge of funding. We are so poorly funded that we're not able to do the things that we need to do. For a faculty such as our faculty, we also have to deal with aging infrastructure. Our faculty building has been standing since, I think, the 70s, or maybe since the 70s, and that you can imagine what it will require to maintain that structure, but unfortunately, we're poorly funded.
Alumni Association always help the growth of the alma mater. There's no doubt about that.
In fact, there's hardly any country I visit that I won't run into a former Unilag student.
Now, I think the role of alumni, I think, is to promote the institution. I mean, you've benefited from the institution. I mean, I can say for sure that my Unilag degree was the platform on which I built a career. And I think we ought to remember that and try and give back to the institution to build its reputation and to support those who are coming behind us.
If you want a faculty to develop, or a university to develop, the charge is on the alumni. The alumni own the university, and they own the faculty, and they make or break the faculty. As I said, when there was thought about changing the name of the university to Abiola University, the faculty alumni rose as one to resist. And people like Ndoma Egba, who was leader of the Senate, Awole Olanipekun, and 6 sons went to court to challenge it. And eventually, it was the alumni that killed that idea. Jonathan could not tamper with that university.
The lecturers that we had were fantastic. University of Lagos has always been the place to be to study law, and I still think it remains the same today. And this is what, as an alumni association, we're going to ensure that in perpetuity, this will remain the case. It will be the best place to study law in Nigeria.
The year the set of 1980 to 1983, at the day that I got to Lagos and the day they left Unilag, they have been taking me along with some 2 or 3 other lecturers to everywhere. They have their annual reunion. They took us to America. They took us to every part of Nigeria. And at present, they are asking them to foot the bill in building the tower for Unilag Faculty of Law. And I can tell you, in this particular group, wow, the judges among them, the SAN among them, and the few that have gone to something, you just mention, and I think they are the best of the universe has produced. Ask the Vice Chancellor or anybody, 1980 to 1983.
This reunion that is tagged the Great Homecoming is going to play a very big role in the Faculty of Law, in the lives of our students, in the lives of those who are coming, because we're expecting the alumni, they are coming back. You know, like a lot had actually left and they never really came back to the school, but you know, they come back, they relive the old time, they acquaint with their classmates, and they also interact with the new generation, which will make a great impact in the lives of the students. And we're also expecting that, you know, they will also give back in kind, in cash, to the university.
Of course, we're everywhere abroad as well, you know, making our rank in the judiciary abroad, in other sectors, even in governance abroad. I think the Attorney General of Alberta State in Canada is an alumnus of the Faculty of Law. And of course, you know that the Speaker of the House of Representatives of the Federal Republic of Nigeria is an alumnus. You do know that the Vice President of Nigeria is an alumnus. I mean, so I think that by all standards, we are definitely an institution to be reckoned with.
Even as we speak, I do not see any dean that do not or has not over the years engaged the Alumni Association for some support, one form of support or the other. So they are development partners indeed. They are development partners. But what I think is that given the value that they add to development, I think it is imperative that we systematize their intervention, we increase and deepen the value, or the depth of our communications with our alumni, so that at least they recognize that it's not just about asking them for funds, in our programs, but actually making them partners at the relevant stages of legal education.
The alumni are very great stakeholders in the functioning and achievement of the university.
University faculty has done a lot for me and a lot for many of my colleagues. So, having appreciated that and acknowledged that, I believe and I entertain no doubt that to whom much is given, much is desired. If we have taken so much from that university, then it's time for us to give back. And that's why I chair the Alumni Relations Committee. And our objective is to bring back as many of alumni that are leaving. Let them come back to university, come back to their faculty, see what the faculty is like, throw banters, some bonding among themselves. It will also afford them the opportunity to interact with our students, see where they are, what are their needs, particularly in the area of placement for internship. If you look at it very well, Oxford, Cambridge, and LSE, UCL, you find out that they also have similar arrangements. And the students are the beneficiaries. Most law firms that are successful would pick their own alumni first for employment before picking any other person. If you look at these chambers, for example, 90% of the lawyers are from University of Lagos. And it's for a reason. I would rather take my own product first before considering other products.